So kindly fix it that in next week.
14. CD,
14.
we have not received CD yet.
No one, CD not listed.
Can be any date on next week.
On my lord, 1st of September.
To let the next
Of September, maybe he is in custody.
Oh, custody.
custody.
Then my lord, on 22nd of August, man.
We'll do 22nd.
22nd.
Yes.
Highly obliged.
Late with Lordship. Would you back to mention item number 7?
CD not received. Issue reminder 22nd of August.
My lord, 17, 18 and 31. My lord,
17, 18, 31. These are
31.
connected.
CD not, your lordship, my lord, all these matter may kindly fix on 18th.
Similar matter is fixed on 18.
Similar matter.
Yes.
17, 18 and 31.
31.
It may take some time. Demand matters. It matters. 18 to 30. How large is it? 17, 18. Yeah, one. Information because matter it will take time. All method. And then 22nd. 18 or 22nd. We did. Right. So one more matter is on fixed on 18, so we are listing out on 18.
Obliged.
All the matters 18 it will go. 17, 18 and 31.
May it please your lordship. Lordship, item number 8, lordship.
CD not received, issue reminder.
Item number 8, lordship. It's a motion matter BA, lordship. Lordship, another bail application arising out of the same FIR is listed before your lordship tomorrow, lordship, for bail hearing, lordship. So could this matter be taken up also tomorrow along with those matter, lordship? It is listed before your lordship as item number 10 tomorrow for bail hearing.
Tomorrow.
Yes.
List on but there.
Along with lordship.
8, 2025. Along with yes.
PA number 2355.
Along with PA number
2355.
2355.
2025. For bail hearing, lordship. Obliged.
May I please the lordship? May I please the lordship? Lordship, for item number 32 and 33, today we are filing objection, lordship. So matter may kindly be adjourned. 33. 32 and 33.
I is for what? I want I is also there. I
Yes, for against that, the new IA they have filed. Against that IA, we are filing objection, lordship.
and otherwise in criminal in revision petition you are the petitioner.
Yes, yes.
Petition. As other side you are appearing.
No.
Mr. Mannan is there.
Manani.
Have you informed him?
Yes, sir.
I had to take it with the consent of the other side. The learned counsel for the respondent, Mr.
Arenda.
R.N. Bus, did for an adjournment stating that some more time is required to file their objection against the present interlocutory application. Prayer allowed, list accordingly, both 32 and 33. You need 2 weeks, will do. Okay. List after 2 weeks. Was there any
Interim.
list after 2 weeks? Interim be continued till next date of
Lordship.
May I please your lordship? Lordship, I am praying for listing of a bail application which was filed yesterday.
We are full with 18, 19, 20. This one. 20.
May I please your lordship? Lordship, back to mention item number 20, lordship. CD was called for, lordship.
20 CD not received, my lord.
Are you on interim there?
Yes, lordship. Interim may continue, lordship.
CD not received, issue reminder. Interim be continued till next date of listing. List accordingly.
On 9th of September, my lord.
Obliged.
Lordship, I beg to mention for listing of a previous bail application for motion for tomorrow.
20.
Listing for one AB lordship, it may come upon tomorrow,
No tomorrow. We are already put, maybe on 20,
20.
or 19th, 19th.
Day after tomorrow then.
No, we are not in a construction. Day after tomorrow is a holiday.
Some urgency there was one
No
medical
emergency.
student.
It's a AB only. No urgency. 19.
Okay.
So we may make opportunity for this.
My pleasure.
Yes. You want to withdraw it?
Yes,
Why?
my lord.
He already got arrested or what?
Not, my lord.
From under instructions. You are Mr. J. Ali?
Yes, my lord.
Heard Mr. J. Ali. Done a consultative petition also heard Mr. P. Potter. So and so. With the instructions of the petitioner, it is submitted by Mr. Ali that he wants to withdraw it. So and so. Disposed of. Okay, it will be disposed of on withdrawal.
My lord. I'm obliged.
Wait, Procedural lordship. My lord, 483, my lord, bail application, my lord. Earlier, my lord, petitioner was arrested in connection with Manipur PS case, my lord. Here, my lord, lordship was released to analyze on bail, my lord. Case 21 is the bail of the water, my lord. Subsequently, what happened, my lord? He was shown arrested in connection with another PS case, my lord. Finally come to the FIR, your lordship.
21 was the bail order. He was granted bail
Yes,
earlier.
yes, my lord.
Acha. In case
Wherein
of
the
another.
petitioner was arrested, my lord.
Huh?
Wherein the petitioner was arrested, and your lordship 21, my lord. Case 21.
Yes. In that
Yes,
case,
sir.
he got bail.
Yes, my lord.
Acha.
Subsequently, what happened, my lord? The petitioner was shown arrested in another case, my lord. Of every PS case number. Lordship will find the order, my case 15, my lord.
Case
15, my lord.
yes.
Yes,
Case 15.
this is the order, my lord.
Mm.
This order was passed in connection with of every PS case number 59, my lord. It is another case, my lord.
It's okay. He got arrested in another case
Yes,
on the
Yes, ma'am.
on production warrant. He was brought up before
Yes,
the
yes.
court and accordingly the
Yes,
order
yes.
was passed. Now what do you want?
Now, my lord, another co-accused, my lord, in the OFP PS case number, my lord, he was already granted bail, my lord. Page 18, my lord. Now, my lord, since the petitioner is shown arrested, my lord, so he could not be get out, my lord. So I am Vipul Roshi, my lord, to grant him bail, my lord, in connection with the OFP PS case number, instant case, my lord. And 58 days, my lord, already there, my lord.
How many days?
58 days. 58 days.
No, here in the present case, how many days?
My lord.
In the present case,
Yes, my lord. In paid case also, my lord, she was shown arrested, my lord. Right order, my lord.
21/6.
Yes, my lord. And moreover, my lord, means another co-accused has already enlisted on bail, my lord.
It seems that he is a habitual offender. No? Earlier also.
If not 58, 52 days.
Yes, 52 days.
Why are you saying 58 days? Where from you are saying 58 days?
52 days. And since my lord,
Now,
co-accused
we
has
are not in
already.
a position to say anything. Yes, obviously 52 days is a quite considerable period. He is in custody.
Yes, my lord. So, my
It
lord, one of
was
the,
a theft in a jewelry shop, I think.
yes, my lord.
Huh?
That one co-accused, my lord, page 18 already shown,
Yes,
my
yes,
lord.
I have seen.
That already has granted bail. She was also, my lord, arrested, my lord, in connection with the present PS case, my lord. She has already enlisted on bail, my lord.
Only because co-accused granted bail, that cannot be a ground.
Then
for-
not
Yeah,
ground,
that
I'm
cannot be
not
a
saying that co-accused.
So have you annexed the scissor list and all, anything here?
My lord,
Scissor list, have you annexed?
nothing, my lord. In this case, my lord,
No, nothing. You have
my lord,
annexed
here,
scissor
in
list.
this case, my lord, neither petitioner was named FIR and nothing, my lord. He was just shown arrested since he was arrested in another case, my lord.
No,
Manikpur
I'm
case.
not on that. Have you submitted any this scissor list? Because scissor list may be there, not from your petitioner, but from others. That's what I'm saying. You have not annexed anything.
No, my lord. My lord, moreover, my lord, page 19, my lord.
It seems recovery was.
Yes,
there.
ma'am.
Yes, Bhattakur, anything? to say?
Yes, yes.
Any short date may be fixed, well, considering that he is a habitual offender and only because one co-accused granted bail, because thereafter, my lord, one another co-accused again tomorrow come, my lord, on the basis of that order, my lord, it will create difficulties. So, my lord, at that point of time, maybe some seizure list all, etc. annex going for the seizure list.
Seizure list, they have not annexed, but obviously in the page 19, it reveals that there was some recovery from a jewelry shop.
Yes. There is some, and
That's
the one
And it-
Javed Ali stated that all these accused persons were involved in committing the offense and multiple occasions they are uh,
Very habitual.
yes, habitual, considering that down and
But most probably 8 days left. Will it be able to furnish? It is already 52 days. In custody.
then I'll try to get the report whether any subject submitted in this case.
5/14 or what?
I will leave it to your achievement. Considering
You are Mr.
Yes, sir.
only considering that.
Heard Mr. S. of the learned counsel for the petition. Also heard Mr. P. Bhattakur, the learned additional PP appearing on behalf of state. This is an application, the section students in connections. It is submitted by Mr. Hawk that the present petitioner is innocent and has not committed any such offense in the as alleged in the FIR. He was uh, inside the jail premises in connection with any other case, wherein he also got bailed, but subsequently, but on 21/6/2025, he was shown arrest in the present case. Nothing has been seized from the possession of the accused petition. However, from the order passed for the co-accused in bail application number 2428 of 2025, it seems that there was recovery of the jewelry from a jeweler shops. In the present case also, he is in custody since last 52 days. And hence, considering the length of detention also, he may be released on bail. Co-accused has already been granted bail by this court. And considering the case of the present accused petition in the same footing, he may be released on bail. However, he is ready and willing to extend his cooperation in further investigation of this case if he is provided with the privilege of bail. Next paragraph. Mr. Bhattakur, the learned additional BP raised objection and submitted that from the forwarding report itself, it is seen that the present petitioner is a habitual offender and he was arrested in multiple occasions in several cases. And hence, considering his conduct of the petitioner, the prayer may not be considered at this stage. Further, he submitted that the bail for the co-accused cannot be the ground for seeking bail in the present case. No, granting bail to the co-accused, granting bail to the co-accused person may not be the proper ground for considering his bail application. Next paragraph. During the submission made by learned counsel for both sides, I have also perused this record. And it reveals from the reporting report that the present accused petitioner was arrested earlier in several cases. Of similar kind of crimes. But without going into detail of the merit of the case, only considering the length of detention, I find that further custodial interrogation may not be required for the purpose of investigation. Considering this aspect of the case, the petitioner is thereby allowed to go on so and so. In whose satisfaction this is?
SDGM, North Salma available.
SDGM,
North Salma available.
Huh?
SDGM, North Salma available.
SDGM,
North Salmara at available.
SDGM bracket M লিখিব, not Salmara available.
I'm obliged.
Yes.
Report was.
Report was called.
No case pending registered against the accused.
No case is back. In Sipajar, you are saying, na?
Yes, yes.
Heard Mr. M. Alam, the learned counsel for the petition. So heard Mr. P. Potter, the learned petition, bring on behalf of state respondent. So it is submitted by Mr. Potter that the report is received from the OC of the concerned police station, wherein it is stated that till date no case has been registered against the present petitioner, namely Mohammed Ainul Haq, in Sipajar police station. So in view of this, the present anticipated bail application is hereby closed. However, the petitioner is at liberty to approach the appropriate forum in the event of registering any case against him. With the above observation, the present petition stands disposed. Keep the report received from the Sipajar police station be kept with the case.
May not harass the petitioner.
No, you are not case. How many blanket order can it be? In spite of that, we are passing the order that you are at liberty if any case is raised. That's obliged.
Item number 3 and 4, same petitioner minus report not yet received.
Report not yet received.
Report not yet.
Yes, when it can be.
On 21st of August 21.
Will do. 21st.
Well,
You are Mr.
NZ sorry.
Hard Mr. N.T. Chaudhary, the learned counsel for case same order. So it's 3 and 4 AK. But petitioners are different. Would you order group order line to same? Also hard Mr. P. Potter, the learned additional PP paying on behalf of state respondent. And it is submitted by Mr. Watford that the report is not received from the officer in charge of concerned police station. Stop in this regard, the learned additional PP is hereby asked to make communication with the OC of the concerned police stations. Release the matter accordingly on 21/8/2025 for report.
Problem.
Yes, sir.
Matt, please, Your Lordship. Here in this case, Lordship, FIR, your Lordship will find page 14. Yes, relevant portion at page 17, Lordship. Here, the allegation was that the police received an information that some Areca nuts are loaded in a truck. And they accordingly went there and suspect that these are Burmese suparis, and therefore accordingly they seized the truck along with the along with those Areca nuts. Now, my case for your Lordship is that I have purchased those Areca nuts from local people, Lordship, that I have annexed the invoices also. Those your Lordship will find from page 22 to 27. from whom I have purchased, those invoices are there. Page 22, your lordship will find that I have purchased from Sohidur Rahman, 2000 kg. Page 22, your lordship.
Yes.
2000 kg. Then page 23, your lordship will find that it was purchased from Asar Ali, again 2500 kg. These are up to, I have given up to lordship, page 27, those invoices are there. And after purchasing in small quantities, lordship, he used to transport it to other state for other seller, other purchaser, lordship. And that your lordship will find that tax invoice. When he used to sell, then only he has to pay the tax. That your lordship will page 28, tax invoice. First top, your lordship will find left side, MB Bamboo shop. That is his mother's shop, registered. And then consignee, your lordship will find SA Enterprises. It was supposed to sell to that farm, lordship. And in that case, lordship, he also paid GST. That your lordship will find page 28 down below, 1,05,000 tax amount that he paid. And then lordship will find page 29, that EWA bill, Annexure 6. EWA bill was generated, and thereafter lordship, these articles were, they were loading in the truck. Police got the information, they went there and they apprehended on the suspicion that these are Burmese superhits. Now lordship, after seizure, lordship, he filed a Jimma petition. That order, your lordship may kindly see that I have got subsequently lordship order. It was passed, so I could not annex it. Serial number 3, lordship may kindly see that scientific opinion regarding those areca nuts. May I read? The food safety officer Dhubri has clarified that the seized areca nuts conform to food safety norms and do not pose any known public health risk. The Forensic Science Laboratory Kahilipara has detected the presence of arecoline, a natural alkaloid inherent to areca nut, with no trace of chemical adulteration or toxic additives. So after that, Jimma was given to his his mother, Lord, the petitioner's mother, because the whole entire business is in the name of petitioner's mother. Being son, he used to help, Lord. So accordingly, that Jimma was given after that observation. So my whole case is that these are local areca, which scientifically also proved, Lord. And he has purchased, from whom he has purchased, that documents is there. To whom he is selling, that documents is also there. When he is selling, then only he required to pay tax, lordship. And accordingly, he paid, lordship. So no infirmity is there in the present case, lordship. At present, my prayer is that interim protection may be given, and if required, case diary may be called, lordship. He will produce all the relevant papers before the IO also. And because of this pending case, he cannot go to collect those Jimma, lordship, Jimma of those articles.
Well, everything is okay, well, everything is genuine, my lord, document, invoice, but they were transporting all those, my lord, areca nuts by way of hiding in a secret manner. How, your lordship, the presence of the illegal Burmese superhit concealed inside the container, my lord? What, if everything is genuine, then where is the requirement of, my lord, transporting these, my lord, areca nuts in a concealed manner, my lord? And thereafter, my lord, only your lordship may kindly come to the last portion of the it is suspected that the said goods are stolen from, and a nexus of high-profile criminals are involved in such illegal business of cheating and evasion of taxes. So, my lord, everything is, my lord, illegally transported only because of, my lord, for evasion of taxes, my lord. These are economic offenses, my lord, only for, my lord, depriving the state for the, my lord.
It is
And my
suspected
lord,
that
regarding those documents, genuineness of those documents, my lord, regarding GST paid receipt, that's also, genuineness also needs to be verified. Only CD will reveal, my lord. And otherwise, my lord, prima facie, it seems that, my lord, they were illegally involved in illegally transporting those, my lord, areca nuts in a concealed manner.
In the FIR, it is alleged that it was loading from godown. So godown, the place of godown, that is not a hidden place. It was there and they were loading from the godown to the truck. Lordship. It was not a in a concealed manner. Lordship.
How they transported
Because
those,
every time they goes and arrest
Mr.
the,
Bhattakur is saying that the way you transported
yeah,
those the in a concealed manner. I
no,
mean,
not
those
transporting.
concealed were
Lordship,
there.
Lordship, may kindly see the first part of FIR.
kept hidden
Page 70.
bamboos inside the container. Burmese
Base
supplies
certificate
kept
is okay,
hidden.
but the way you transported, that's what I'm saying.
That, Lordship, they were loading. At loading time,
Only for, these are,
and all documents are there. Zimma is given after seeing all the reports. Lordship.
racket is involved in transporting in all these businesses, only for evasion of tax.
Supery syndicate is,
And one more thing, Lordship, that the entire business is in his
it
father,
is
mother's name.
very profitable business.
Yes,
so
yes, madam.
That
This
is what
Supari-
they
my lord,
locally
in many-
used to
because we
purchase.
heard that this
And in
Supari
many cases,
syndicate
my lord,
and
those-
Koila syndicate,
yes.
these are the what we heard.
Actually,
It may be very profitable.
Of the record, if I say, Lordship, that if someone works outside syndicate, then it is illegal. If they
And-
works inside syndicate, then there is no problem.
And in
That
fact,
is
my
the
lord,
difficulty.
No such profit.
No.
in fact, my lord, in some of the cases, it is found that those GST challans were also, my lord, during investigation fake. And my lord, group is involved in, my lord, creating, my lord, those invoices.
that I have
GST,
also
my lord,
come.
challan.
There are
In
cases.
fact, they have not, my lord, submitted any GST before the authority. My lord. Those even prepared, take GST challans were prepared, invoices were prepared. Thereafter transporting all these Americanas in a illegal manner.
Yes. I have also come to.
No, that genuineness of all those documents
Is
needs
required.
needs verification.
Heard Mr. A. Ahmed, and counsel for the petitioner, and also heard Mr. P. Bhattakur. They done an additional PP appearing on behalf of Secretary. This is an application under section so and so in connection with so and so. Next one, it is submitted by Mr. Ahmed that the present accused petitioner is a genuine businessman and
His mother, Lordship,
his mother.
Yeah.
Otherwise, he is a businessman in the name of mother.
in the name of mother.
Uh,
That document, your
businessman
Lordship,
and,
page 10.
And the said business establishment is in the name of his mother, which is the business establishment, namely MB Bamboo Shop, is in the name of his mother or father,
Mother,
Mother.
page 10, Lordship, will be there.
a mother, and which is run by the present petition. The the uh, the uh, the vehicle along with those Erekanats were seized with a suspicion that these are the maybe the Burmese super. But it is submitted, but all the superis were purchased by the present petitioner from some local traders, and to that effect, he has also submitted all the invoices and the invoices. Further, he submitted after collecting the superis from the local traders. He used to transport it to the other states, and it was ready for transportation. And to that effect, he also submitted the tax invoices, wherein the GST is also paid. So Mr. Ahmed further submitted that the father or mother
Mother.
of the present petitioner also paid for Jimma of those Arakanas, and after considering the report of the scientific expert, it was held by the learned trial court below that the superis are not the natural one and had no traces of any chemical adulteration or toxic additives. In view of this, the superior is also allowed in favor of Jimma of the mother of the petitioner. However, the petitioner, in apprehension of arrest in connection with this case, has filed the present petition seeking the anticipatory bail. He further submitted that he produced all the documents, including the tax invoices and tax challans, etc., before the IO, if he is provided with some interim permission. Next one, Mr. Waterford, United Additional People raised objection and submitted that from the from FIR itself, it is seen that those Arakanats were were transported in a transported, keeping them in some container in and concealed and thus concealed the and thus transported in a concealed manner. Further, there may be a nexus of the other people, and those Arakanats were supposed to be transported to the other states only and with the intention to for evasion of the taxes, which is otherwise like a economic offense. Further, Mr. Waterford submitted that the genuineness of all those tax invoices are also to be verified by the investigating authority. And accordingly, he submitted that the CD will reveal the actual facts. Next one, hearing the submission made by learned counsel for both sides and considering all aspects of the case, including the tax invoices and tax invoices, etc. And other annexed documents, I find that one opportunity may be given to the present petitioner to appear before the IO and to cooperate in the investigation process. In view of this, I find it efficacious to extend the privilege of interim pre-arrest bail. Okay, will be under interim protection, provide all these documents before the IO so that it can be verified.
Lordship.
11,
11. Please tell me.
Obliged. Item number 6 is also same that he is the Lordship transporter who gave the truck to the other petitioner. Provided truck.
Hello,
He
regarding
is having the transport company that tenancy agreement also I have given from where he is operating his business, page 10. After noticing all those documents, he provided his the truck, Lordship. That much involvement he has. And truck also, Lordship, given
In connection with the present case only. Same
same affair. And the truck and Arakanats were seized. That other petitioner was connected with the Arakanats and this present petitioner is connected with the truck. He provided the truck for transportation because he is
He is the
operating a
owner
transport-
or what? Not owner.
Not owner. He is the agent of transport company, Lordship. And that vehicle was also given Jimma to the owner, Lordship.
regarding Zimma, my lord, I would like to submit one thing, my lord, regarding interim custody of those Ericanats and my lord vehicle. That is, Zimma interim custody granted only because considering the perishable nature of the my lord materials. That cannot otherwise, my lord, help the petitioner for obtaining any interim possession before this regarding the present case.
No, but the
Yes.
provided the report that those before giving Jimma of those Arakanats, obviously it is a perishable one, but the ownership may not be in that manner, may not be there, or the other related document as you have submitted those invoices or tax invoices
Yes.
may not be genuine also.
Yes.
And that is one aspect. But the Arakanats may not be the permit superior, or it may be I mean consumable by the
Yes.
human being. That will be the only report.
Yes.
On the basis of which the Jimma was
Jimma,
given as
yes.
because it's a perishable one.
Yes.
And the other one, the truck, maybe the owner may be this, that's why the truck may be okay, the one.
Only
We are only noticing all these documents he has provided the vehicle. That much
What
involved.
noticing?
These tax invoices and other documents after the trade license. After noticing these documents, he has given the truck for transportation.
Only in view of the decision of the my lord Sundar Bhai Ambala's decision, only because of
Yes, that is there. So he is basically an agent of the transport company.
Lordship.
How many trucks he provided for this purpose?
Only
Only
one. One.
So you are saying that after consulting with all these documents and all, he transport.
He given the truck.
He is not associated with those
No.
Arakanats.
He is not associated with the business. The business of Erekana.
Regarding the present petitioner, well, some strict conditions, maybe he is from Haryana, my lord. So he,
Is from
Haryana. My lord.
That may be there, but as per
Look
my
at
instruction,
POD.
Lordship, he is residing there. By residing at that place, he is running the business. If any strict condition is put, no, he will abide by that.
same work, okay, hard Mr. Ahmed, so and so, so and so. It is submitted by Mr. Ahmed that the present accused petitioner is no way connected with the alleged offense, nor he is the nor he is dealing with any business of Arakanats. However, he is working as a courier agent and the agent of a transport company, wherefrom he given the truck for the seat consignment. He further submitted that while delivering the truck for the to transport the Arakanats, he verified all the tax invoices and the challans, etc. And thereafter, finding it the genuine one, he delivered the truck for for transporting of the consignment. Further, he submitted that the owner of the truck also paid for Jima of the vehicle, which has already been given in favor of the owner of the truck. The petitioner is, however, still ready and willing to cooperate with IU in further investigation of this case if he is granted with the privilege of interim pre-arrest. Next, Mr. Waterford, a learned petitioner PP submitted in this regard that the present accused petitioner may also be involved in the offense, and furthermore, he is from
Haryana.
Haryana. He is from Haryana, and hence his presence, and hence procuring his presence may be difficult on the part of the investigating officer also. And accordingly, he raised objection and submitted that custodial interrogation may be required for the present petition. Next paragraph. Hearing this submission made by learned counsel for both sides. All other aspects of the case, I find that one chance may be given to the present petitioner. So and so credible. However, as the petitioner belongs to another state, the IO may put some conditions to procure his attendance, as well as to procure his attendance in the interest of the investigation. But okay, আমি একটা condition ভৰাই দিব পাৰো. We'll see. We may put also conditions. Same time date কৰিব. It's 11/9. 11/9. Same.
Appear within 10 days, Lordship.
10 days. That may be appeared within 10 days. Both depends.
Yes.
Obliged, Lord.
Wait, please, Lord.
Yes.
My lord, FIR page 10, my lord. Is the FIR translated parcel?
Page 10.
Yes. Allegation is there on 9/7/2025.
Hmm.
Some person attacked the informant and snatched away, he was attacked and assaulted and snatched away rupees 32,000 along with a chain. That is daily. Accordingly, one person has been arrested.
No, it's a case of theft.
No, my lord.
What?
There are 61
What's
to
that? The 61 is.
conspiracy of the grievous hard, my lord. 109 309 cold robbery. Yeah. My lord, one person has been arrested. You'll also kindly peruse the, my lord, forwarding this. Page 17, my lord. The present petitioners, my lord, they were named in the FIR. But you'll also kindly peruse page 17, the forwarding report type of.
So you are for the whom?
I am for the, my lord, one Vikas Kurmi and Krishna Kurmi. One person has been
Vikas.
arrested. Yes,
Vikas and Krishna.
Accused number 2 and 3 in the.
their names are there, my lord. But one person, Bastov Kurmi, my lord, he was arrested. Page 17, my lord. Kindly see the grounds of arrest. That the nature of crime of the accused person has committed is the heinous and non-bailable. There is risk of so and so many. Testimony of victim gives solid confirmation of alleged crime committed by the accused person. Statement of PO witnesses give solid confirmation of alleged crime committed by the so and so. There is nothing against the, my lord, present petitioner.
So it is
The
him
ex-
only.
Actual fact,
For him only that is the ground of arrest. for
actual
that
fact you
petition.
will find next, the FIR lodged by the arrested person's wife, my lord. Page 21. One
Petitioner lost it. Arrested person.
arrested person, wife has also lodged an FIR. Page
But
20.
you see, the nature of case, if you go by the FIR also, we don't know the other aspect when they may be. It cannot be a case for anticipatory, I think.
Kindly see, my lord, the FIR lodged by the wife of the arrested person, page 21.
Page 21.
Yes.
Hmm.
Assamese version, page 23, my lord.
Hmm. Why she lost the FIR?
My lord.
Why she lost the FIR?
My lord, it is the, my lord, the informant who has attacked the husband of the informant, the second informant. That is the case, my lord. And you'll also kindly peruse that the page 20. May I read, my lord? With due respect, it is to state that there is a fight on 9/7/2025 between two persons, my lord, with the above name accused. On that, while my husband was on company's duty, the father-in-law fell sick due to high blood pressure, so he directly went to Pasnoy for purchasing medicine at about 10:30 p.m. from his duty. While coming back home in the aforesaid place, he met the accused. That means the informant of the present FIR, my lord, the FIR against which the petitioner is seeking bail.
That your FIR is also registered?
My lord, it has been registered by, since the petitioner is apprehending arrest, my lord, its certified copy could not be collected.
No, your FIR is registered or not?
Second FIR is also registered, my lord.
Acha. Registered number?
My lord, that I could not place before this on court because, my lord, the present petitioners are, my
You
lord,
cannot
apprehending,
place before this court
my lord.
because it is the wife, not by the accused. Only wife lost the FIR.
The
So-
person who has been arrested, my lord,
His wife.
his wife lost his FIR,
It's okay,
giving
then
the
what?
actual facts, my lord, wherein we are
No,
not
that's
involved,
what.
my lord.
She can collect the case.
My lord.
The registration number and all, she can collect. From here, which you have annexed.
My lord.
It's nothing
She
is
can
here.
collect, but
You
she is
cannot
not,
say whether it is registered, not registered, subsequent,
my lord,
or before the other one. We are not in a position to say anything.
my lord.
It's a merely case made out by you only. Yes, what about anything?
On my lord, 21/8, I can produce the case in 22/8.
My lord, since the subsequent FIR gives the actual fact, my lord,
Now see, this
stating that
is
we are,
your case. That is the actual case. That is not yet registered also. So
Well,
we are not in a position to say anything.
it has been registered, my lord,
Because
so far my knowledge.
the allegation made in the other FIR, the present FIR, is very serious allegation. How can?
Well, in the
It's
grounds
not
of
a case
arrest,
anticipatory, what I'm saying. Not
it's
case
true, my
of-
lord, but in the grounds of arrest also, well, there is no mention of any involvement of any other person except the arrested person.
No, that is not there. That is not there. These other questions will be responding and these are there. Only.
In the grounds, my lord, there is nothing,
Against you, the petitioner got arrested.
my
The,
lord,
but the person who got arrested,
my lord.
against him, those the grounds of arrest. Why he got arrested? There may not be any ground. But
Police
that
may
cannot
very
be
well
because
say
you
some
are the
other
FIR
person.
accused. It's not the case that you are suspected or you are. It's not you are specifically your name is there in the FIR.
My lord.
So then, what to say?
But
Yes,
my,
well,
my
if
name is in the FIR, my lord, that's right, my lord.
What
But the subsequent FIR,
21
21/8, ma'am.
Based on 21 CDB.
some protection, my lord, since the
Protection
subsequent
is
FIR
dispatched
discloses.
this case, how can the protection may be there? Cannot be. It's not a case of anticipatory.
Then, my lord, the
21/8.
date may be preponed, my lord, kindly, my
21/8 I'm listing, but thereafter, if you want to insist on that, then it will go up to September. You don't have any. 9, 10, 11, same.
This matter was hard, earlier.
Hard earlier.
Yes, my lord,
Why?
here, my lord, our main ground is that, my lord, section 47 and 48 of the BNSS was not complied with, my lord. And the petitioner is, are in jail for nearly 6 months, my lord. Arrested
So
on
it's a charge sheeted case.
charge sheet case.
Acha.
For
9,
theft.
10 and 11. ne?
My lord,
No.
my before starting my colleague.
Let me can pick up this after some time, Lordship.
Sometime you try to manage it before 1 because from 2 I have received from Arunachal. May not be
I
time.
believe it not. Then on any other day, Lordship. Because Lordship, here Lordship, the regarding 47 notices here, Lordship. So Lordship, there are some
48.
judgments also Lordship, which says Lordship, when there is a warrant, the warrant itself is a counterfeit case.
Those 3 petitioners were arrested on warrant,
Production warrant.
production warrant.
Warrant is warrant, that is also there.
In one case, they were arrested. Then after that, in the, that they were soon arrested in other cases, my lord. But even then, my lord,
Here all the petitioners are different, I think.
no, petitioners are same. All petitioners same, petitioners same. All cases are registered in, at Paneri, my lord. Paneri police station. Regarding theft of, RRU, my lord. Only in, my lord, item number 10, my lord. There was recovery from Tahir and Sukur. But, no theft materials were recovered from, my lord, Mohibul, my lord.
Anyway, when do you want to fix it?
Huh?
At 2,
At 12, my lord.
After some
today at 12. Okay. okay.
At 12.
Oh.
It's been taken at 12.
Lordship, kindly for the timing, my senior is coming, Lordship.
here in this Lordship, in this case, Lordship, CD was called for, scan copy of CD is called for. But it is incomplete, perhaps, because I haven't gone through the entire, I did not find it, the entire CD. Earlier also it was submitted. Not completed.
Yes, yes. On the earlier occasion also that was the case. So then why again same petition is there?
No, the entire
It's
CD is
hasty,
secure
it's
to be
one
seen,
and
but it is not.
Incomplete
today is
CD,
104
public way
days,
আছে
man.
there. Incomplete CD আছে there. One notice there on 6/8 from the office note where it is received as scan copy of the TCR receipt. But now you are again saying that it is not complete one.
But Lordship, the entire witnesses, there are 7 witnesses are there, Lordship. All witnesses statements are not there, Lordship. And
কি
apart
কৰি
from
আছে?
that,
এইটো already কৰা আছে। Here you want to say that this 161 statements are not available.
not available. All not available. 2, 3 is at the Lordship.
And what is the case of the stage of the case at present?
That is Lordship, see,
Active file has not yet framed to our information.
Charge not.
certain,
Should-
certain.
Huh? That case, your lordship
Charge
may
name of-
consider, my lord.
Now it is fixed for evidence stage, Lordship. On
No.
19/8/2025, it is fixed for the evidence. Prosecution call for after 2, 3 witnesses are occurred.
There is nothing, my lord, it is a government, my lord. Basically, that Pahalgam, my lord, he only shared a comment, my lord. This is the offense. Further custody required, my lord. That is, I am
That
on
is
that subject to your lordship, my lord.
You are in custody since when?
104 days, man.
100.
104 days.
Any
Arrested on-
comment, any comment
No,
regarding
not
that
comment
person?
shared.
Whatever it is, that is also
No,
among
that's,
the
the-
comment also.
I'm not disputing
And
that.
his comment is also Hindu ko fail diya, this type of words are there. So this is not a simple comment. This is not a simple post.
No, not
When
comment.
when entire nation is against this brutal killing, Lordship, then he was sharing such kind of comments. This is not.
Just you know, have a look to my lord that here. That this kind of sharing, depicts suppose shared accidentally, my lord, his mobile, that would, this is the accidentally, he did not make any comment, my.
Somewhat when somebody was touching the mobile, my lord, that this is a special statement here.
Actually, that is
But nothing happened, madam. None of the section is attracted here, madam. Nothing happened. No communal violence, no endangering the sovereignty, nothing at all. Simple, my lord, he grocery shop owner, my lord. He is not a big man that who can influence some society, do something. Madam. Grocery shop, my lord. He is there. I lift your lordship, madam. Further
Yes,
cut,
what to
in
say?
my opinion, my lord, not right.
So regarding that, that is why also that has to be looked into also, whether that was only sharing, whether that
It
is
is there.
their lawsuit, everything has to be, this is a FIR lawsuit. We will not go by the, after filing of search sheet, we will not go to the entire FIR, only on the topic, statement of the FIR lawsuit. We will go by the entire statement of the, what the, witnesses statements are there lawsuit.
Police has filed the
So
case.
lawsuit,
Well, there is no witness, my mobile, my lord.
Same thing happen আকৌ আহিছে কি আধাৰ order reflect আছে raised he directed to call the complete scan copy of the TCR along with the scan copy of this case diary. Scan copy of the case diary is not complete. The petitioner is behind the bar. That is the true fact. Last not to একটা scan copy পাইছে। আমি কৈ আছিলো যে এইটো আচলতে দিছিল অৰ্ডাৰটো সেইটো PCR আৰু সেইটো not available মানে some of the witnesses are not available এইটোৱে কৈ আছিলে এইটোৱে নাই নহয় এতিয়া একো নাই this has to come from which place?
Chapo, my Dubri Bechil, Dubri district.
Chapor Dhubri?
Yes, Chapo. Dubri. You can give a question to the person.
Minimum.
Because the Rasif in last 20 years practice Rasif, only limited practice Rasif. I have not seen, ever seen that Rasif, the court is having reference for any kind of killing or other things Rasif. But here in our only in this occasion Rasif, the court is court had some reference because of this brutal killing Rasif. And in that case Rasif, person is making such kind of comments regarding that issue Rasif. That is not
So nobody is disputing, madam. Nobody is
It
disputing.
hurts from the every Indian.
Nobody disputing, madam. Well, not a comment, madam.
So
Share
that's,
accidentally, it is
a
on both hearsay.
accidentally, yeah, or accidentally it was there, or that will definitely reflect in the entire city because there is no iron notes are not there, or only 2-3 statements are there also. So everything has to be.
It is not eyewitness, madam.
And
It is
definitely-
sharing of the mobile, everything is seized, madam. What is eyewitness, madam? What is the witness?
I
What
was
evidence?
statement that
Everything
it
on
was-
record, madam. Everything on record.
He is saying that regarding at the time of investigation, was there any note of the IO? Those are also not available in the
That
case.
I lift your lordship,
That
madam.
is
Only
the-
he is 104.
I also wanted to.
Madam,
dispose of the
I
matter, but the
absolutely your
question is
lordship,
that
madam.
only that's what I'm just asking Mr. Borwa also that why it had happened. In fact, though it was just simply TCR has already been received, now the office note also reflects in that way only. But we
Where's
to
your
receive
lordship?
the entire case diary, in fact. He is saying that it will take minimum 1 week to receive, either 1 week or 10 days. We will try to list the
Madam,
matter.
a special message, I think one WT message, that they can send it even, madam.
No,
Friday also it
no,
may-
they still will do the needful.
I left your lordship, madam, only because of, nothing happened, madam. No further evidence is required. It is all everything on the record now. Mobile says everything is there, madam. I'll face the, my trial.
on 26 also, or
I'll tell the guy.
right?
Huh?
About it.
Why 26? But you have some sense of that here.
HR
Simply by saying you will not do.
Assisted by assisted
For
by.
the sake of opposition, you have to oppose the bill.
You are MS? R Deca. Assisted by MS R Deca. The London Constitutional Petition. And also heard Mr. Yes, Lockport. The London Additional PP appearing on behalf of Judge. As per the office note, this can office note dated 6/8/2025, this scan copy of the TCR has already been received. But by the order dated 28/07/2024, it was asked to the registry to call for the complete copy of this complete copy of the complete scan copy of the case diary along with the TCR. But uh, the but today also it is submitted by Mr. Locker that CD is not completed except one or two witnesses, statement of the one or two witnesses. The other part of the CD is not completed in apart from the note of the IO or the investigation progress or the investigation process. In view of this, the registry is strictly directed to call for a complete scan copy of the case diary along with the TCR, which has to be reached on or before the next date of listing. Positively on or before the next date. Yes. Registry will do the need. These are different. No? Please, 20. 20.
20. Obliged to know.
Minus, it's till today, 54 days, my lord.
Just now we have received the CD Lordship after something. We have just now received.
For some time.
Please, your lordship, on last occasions, CD
15
was.
who is there? But no, it's okay. But two may be a bit different, difficult because I have a VC from Arunachal. It may take time, it may not also. I cannot say this. If hearing goes on, then definitely other rest of the matters may be adjourned. At 2. Before 2, okay, then you sit
We
here.
are going to 12, at 12.
No, we'll try.
It's okay.
I cannot see. Yes, what is the position of 16?
May I please, your lordship? Lordship, the petitioner was arrested on
Just a
15.
second. 16?
Yes, my lord.
What
We have
happened?
already received, my lord. PM report is not conclusive, my lord, regarding cause of death. This is, my lord, only 12 years, my lord.
Yes, anyway, what was what
Lordship,
submit? Yes, sir.
Lordship, the petitioner was arrested on 15/7/2025. As on date, Lordship, it is 29 days behind the bar, Lordship. The crux of the allegation is that, my lord, there was an incident of theft in the garage of the petitioner, Lordship. And allegedly that the victim was involved in that particular incident. And on 23/6/2025, while the victim was coming towards the garage side, he was chased by the petitioner and his co-fellows. And subsequently, he went to the railway line, Lordship, the railway track, and he committed suicide. And the FIR was lost after 10 days, Lordship. Incident took place on 23/6/2025. FIR was lost on 3/7/2025. One more factor is that, Lordship, on the same day, it has been alleged that the family members of the victim boy was informed by this petitioner and his co-workers. But they did not bother to lodge any FIR. After 10 days, FIR has been lodged. The only thing is that, my lord, whether that by confronting someone regarding an incident of theft, whether that amounts to abetment or instigation. Lordship will kindly consider that aspect of the case. Lordship. Already 29 days. Whether further custodial detention for the sake of investigation is necessary or not. Unfortunately, the boy has died, Lordship. But what are the circumstances under which he has died? And whether that amounts to abetment or not, Lordship. Lordship will find the FIR vernacular part, Lordship, at page 14. That will make it clear. Page 14 is the vernacular. Married, Lordship. মহোদয় এজাহাৰকাৰী বিনীত নিবেদন এই যে উপৰোক্ত 1 নং পদকীয়াৰ দিনকৰত এখন বাইকৰ গেৰেজ আছে 2 নং পদকীয়া 1 নং পদকীয়াৰ গেৰেজৰ কৰ্মচাৰী হয় কিছুদিন পূৰ্বে
1 নং পদকীয়াৰ গেৰেজত কিছু সামগ্ৰী চুৰি হোৱা কেন্দ্ৰ কৰি গত ইংৰাজী 23/6/2025 তাৰিখে মোৰ অষ্টমমান শ্ৰেণীত পঢ়ি থকা পুত্ৰ ইমৰান আলী ওৰফে ইৰফান আলীৰ বৰ্তমান বয়স 12 বছৰ 7 মাহ দিনৰ প্ৰায় 4 মান বজাত 1 নং পদকীয়াৰ গেৰেজৰ ফালে ফুৰিবলৈ গৈ থকা অৱস্থাত 1 নং পদকীয়াই দেখা পাই চিঞৰ বাখৰ কৰি খেদি যায়। উক্ত সময়ত উপৰোক্ত 2 নং আৰু 3 নং পদকীয়া সেই স্থানত উপস্থিত আছিল। 1 নং পদকীয়াই মোৰ ল'ৰা ইমৰানক খেদি যোৱা 2 নং পদকীয়া আৰু 3 নং পদকীয়াই দেখা পায় তেওঁলোকেও মোৰ ল'ৰাজনক বাইকেৰে খেদি যায়। তেতিয়া মোৰ ল'ৰাজনে পদকীয়াগণৰ মাৰপিটৰ ভয়ত প্ৰাণৰ ভয়ত দৌৰি গৈ ৰেল লাইনলৈ দৌৰি যায় আৰু পদকীয়াগণে পিছে পিছে খেদি যোৱাৰ ফলত মোৰ ল'ৰাটি মানসিকভাৱে ভাৰসাম্য হেৰুৱাই ৰেল লাইনৰ ছিগনেল লাইটৰ পোষ্টত ডিঙিত প্লাষ্টিকৰ ৰছী লৈ আত্মহনন কৰে। ইয়াৰ কিছু সময়ৰ পিছত 1 নং আৰু 4 নং পদকীয়াই মোৰ গৃহলৈ গৈ পৰিয়ালক কয় যে তহঁতৰ ইৰফান আলীক লাগে যদি ৰেল লাইনত আছে তাৰ পৰা লৈ আহগৈ, আমি দায়ী নহয়। এই খবৰ পোৱাৰ পিছত মোৰ পৰিয়ালৰ লোকেও গাঁৱৰ মানুহ ঘটনাস্থলীলৈ গৈ পোৱাত মোৰ ল'ৰাটি ৰেল লাইনৰ ছিগনেল লাইটৰ পোষ্টত ওলমি থকা প্ৰত্যক্ষ কৰোঁ। ইৰফানক পৰিয়ালৰ লোকে নমাই ততাতৈয়াকৈ হস্পিটেললৈ নিয়ে যদিও ইৰফানৰ মৃত্যু হোৱা বুলি চিকিৎসকে কয়। And the incident has been taken place at 4 p.m. Lordship, in the daylight. So, the entire sequence of the incident, Lordship, will kindly see that he was chased by this person's Lordship in the daylight, in the railway track, he has committed suicide. Nobody has resisted, nobody has seen, nothing, Lordship.
Well, case diary, he already admitted that on the day of the incident, the accused persons along with someone, other persons, one of his employee, he is the owner of a garage, present petitioner, along with his employees on that day, on the day of the incident, he said the deceased. Deceased is a 12, the age of the deceased is only 12 years, and on that day, thereafter, this incident happened. And from the PM report, regarding cause of death kept pending till receipt of the report of FSL report. Till now, the cause of death not yet certain, and regarding your lordship may kindly peruse. Lordship, that is the post.
Why cause of death is not yet certain?
Regarding lung and heart, I am just pointing out both the lungs are congested. Petechial hemorrhages are present at places on the surfaces. On cut section, the cut surface oozes out dark red fluid blood. And regarding heart, congested and chamber contains dark colored liquid blood. Petechial hemorrhages are present at places on vernacular surfaces.
Then to PM report will be
So,
required.
PM report on that.
It's not a case that the
It cannot be
hemorrhages
said
were in different
because
areas.
on
the
that day,
hemorrhages were.
admittedly, he also submitted that on that day, these accused person along with his employee chased the deceased. Thereafter, he committed suicide in a railway.
And that apart, suppose they were changing.
Yeah.
As per them also, they were changing for that
Yes,
committing theft and all. Maybe it's a natural, maybe chase. Quite understand. But while chasing, they were behind him. With a bike, they were chasing.
Yes.
The boy was running.
Because
Then and what time this boy will get such a time to stand there keeping
Yes,
this one again
yes,
and
yes.
holding on? It's quite suspicious.
Suspicious.
People see.
and
Because
railway
he
tracks,
won't get time.
and railway tracks
if
are
suppose
lonely
if-
places,
Pardon?
Railway tracks are lonely places,
Ah.
some areas. So whether there is any, how he committed suicide within a short period of time while
Because they were
chasing-
skating with their bikes.
Yes,
And
yes.
the boy is a small boy, he was running.
Yes,
When he got time,
yes,
standing there again, hanging himself, when he there, quite
yes,
suspicious.
Yes,
Maybe, but quite suspicious.
yes.
And that apart, they are the only person who informed the
Yes.
family members that your boy is there. If you want, bring him. It seems to be suspicious.
Yes.
Okay, we need the report. When is there any note from the IO why it is not there? Because it is not a case that only ligature mark is there, but there are in several parts of the body there are hemorrhages.
I will try to contact the IO to collect the FSL report as early as possible.
Till then you are going to retain the case diary?
Uh,
Maybe retain?
Yes, maybe then I'll try to collect the FSL report.
Because they are saying that they are on custody since last 29 days also.
From 15/7.
29 days.
29.
29. 18 তাৰিখেও পাল পাই।
From 1st of September, 1/9.
Lordship, it will be very long.
Yeah,
date.
22/8, my lord.
No, not both.
22.
There are several.
Many other cases fixed.
21, can it be
23rd
on 21 Lordship?
23rd or
23rd only holiday, my lord.
23rd or
21st Lordship,
the
can
holiday.
it be on 21st?
Maybe on 21st then.
21st.
21st corridor heard Mr. Peter still unanswered for the petition, also heard Mr. P. Waterford. It is submitted by Mr. Waterford at a CD receipt, but the PM report is still awaited. And it is submitted that the PM report will be necessary for disposal of this case. Case diary be retained and Mr. Waterford will make personal communication with the IO to get the PM report. PM report fully to know the PM FSL report to know the cause of the death. List accordingly on 21.
CD may be written, Lordship.
CD be written. We are good.
Lordship. Obliged, Lordship. May it please your Lordship. Lordship, this is a second time regular bail application, Lordship. Earlier, it is rejected by this court on Lordship 18/7/2025. At that time, he was in 49 days in jail custody. Lordship, today is 74 days in jail custody, Lordship. Since it is a rejected Lordship, there is very little to submit, Lordship. Only the length of detention, Lordship. After rejection, whether, Lordship, any further evidence come out against this petitioner, Lordship, that has to be taken into consideration, Lordship. And during so far instruction, during this period, he was not interrogated in jail after rejection of this bail petition, Lordship. Earlier, my submission was that Lordship is only the position 1,540, 500 denomination note, total value was 7,70,000. My submission was at that time, Lordship, since it is a possession, Lordship, so statutory period is 60 days, Lordship. Now, then they have submitted, Lordship. He has a habitual offender, Lordship. He has a previous cases there against them, Lordship. Till that case, Lordship, Lordship, this petitioner was not convicted, Lordship. Now, stand is same, he is accusation only. Now, Lordship, until unless he has a convicted, Lordship, it's very early to say, Lordship, he is a habitual offender, Lordship. Now, Lordship, considering the length of detention, Lordship, 74 days in jail custody, Lordship, whether further custodial interrogation is required or not, that has to be taken into consideration. Otherwise, this petitioner is ready to cooperate, Lordship. If required, Lordship, every alternate day, he will ready to appear before the IO, Lordship, till the submission of the charge sheet, Lordship.
Yes, what?
Yes, madam. Otherwise, madam, from the position of the petitioner earlier also I submitted, madam. He is also involved in other two cases, madam. Bipuria and madam dispute PS case number. I pointed out to you, Lordship, considering that, my lord, grounds of length of detention, my lord, cannot be a ground, my lord, in this case for granting bail, my lord. And many other accused persons also involved along with the petitioner, my lord. And he submitted that this is not a case of, my lord. There are other accused persons also there, my lord. From one Sahil, my lord, where he possesses a printing machine used to produce the FICN, which is then distributed to other parts of the country. Although that printing machine, my lord, I have not found any seizure list, but regarding that, my lord, also the other accused persons along with the present petitioner also, my lord, possesses printing machine also, my lord.
Possess.
Printing, my lord, this.
No, this present petition also possess.
From the position of the present petitioner, that is 7,70,000 of fake Indian currency.
Printing machine from one Sahil.
One Sahil, my lord, not from this. Sahil mainly operates. And in this case, my lord, section 179 and 80 of the BNS also added on 3625. Earlier I pointed out. So, well, considering all these aspects, he is also habitually involved in committing this type of offences. So, length of detention, and these are, my lord, economic offences, my lord.
What is the recovery lordship after rejection of this earlier petition lodge? Till date lordship against this petition lodge.
Already
Scissors printing is not there lordship. Only possession lordship. The previous case he was not till convicted lordship. He is still in the stand of accused lordship. Until a person is convicted lordship, he cannot be said he is an habitual offender lordship. No printing matter, only the lordship. So far, my last submission, it was 60 days. That was not considered lordship. Now, lordship, today is 74 days lordship.
There are offences against, my lord.
Economics offense, they have submitted last occasion lordship. I have also submitted lordship because what is recovered further lordship during this period, what they have collected against this petitioner lordship. Whatever my learned friend has submitted, he has submitted on the last occasion also.
Is sufficient, my lord, FIC, and those were already confirmed by the, my lord, forensic laboratory that those are fake Indian currency note. Those are offences against the nation, man.
That was his last submission also, lordship. That is, he has not improved anything in his submission.
There is no.
That's why, lordship, I pray, lordship, if required, lordship, if every alternative day he will appear before the police station, lordship, that will, lordship, restrain, lordship.
Mr. P. Chaudhary, the learned
Further
counsel for the
improvement in
petition.
administration,
And
what is
also
there
heard
already
Mr. P. Bhatta,
sufficient?
the learned additional VP, appearing on behalf of the respondent. This is an application under section so and so in connection with switch. It is submitted by Mr. Chaudhary that the present petitioner is innocent. He is not connected with the alleged offense. However, it is alleged that 7,70,000 rupees, 7,70,000 with 500 denomination has been recovered from the possession of the present accused petitioner, which is alleged to be the fake currencies, counterfeited. But full stop. His earlier bail application was rejected on 18/7/2025 with the observation that further custodial detention may be required to unearth some more facts in this case. But as per the instructions of his client, the petitioner is not further interrogated in the jail premises. Full stop. Mr. Chaudhary further submitted that there was no printing machine or other materials were collected, so seized from the possession of the present petitioner, except the alleged recovery of the counterfeited currency, which otherwise establishes his case, only under section 180 BNS, which is wherein the statutory period is of 60 days. So the present petitioner is in custody since the 74 days. Hence, considering its length of detention also, he may be released on bail. Next paragraph. Mr. Waterford, the learned additional PP submitted in this regard that the present petitioner is a habitual offender, and against him, 2 more cases are still pending. Further, he submitted that as per from the materials available in the case diary, it is seen that one printing machine was also recovered from possession of one of the co-accused, namely Sahil, though the seizure list is not available in the case diary. He further submitted that from the FSL report also it is confirmed that the currency notes of rupees 500 denomination are stated to be counterfeited one. and counterfeited one. Accordingly, he submitted that length of detention may not be the only criteria to consider the bail application for the present petition. Next one. Hearing the submission made by land counsel for both sides, I have also perused his diary, and it reveals that there is sufficient progress in the case diary, but it is a fact that sufficient progress in the investigation. But it is a fact that after rejection of the bail application for the present petitioner, he was not further interrogated by the police personnel. However, there are sufficient incriminating materials so far collected by the IO during the investigation. But without going detail into the merit of the case, only considering the length of detention which already undergone by the accused petitioner, we find that further custodial interrogation may not be necessary for the interest of the investigation. Next one, DD. To whose satisfaction this one?
CGM Lakhimpur, North Lakhimpur.
The satisfaction of CGM Lakhimpur North.
My lord, that
Obliged.
printing machine not yet, my lord, seized, my not
Yeah,
yet
I have-
recovered, my lord, from
It
Sahil.
it is from the, I know that one printing machine
Oh, yes.
is
by Sahil.
found in the possession of one Sahil,
Sahil.
but seizure list is not there.
No.
That's
Highly obliged.
My lord, not my lord. Sahil mainly operates from Guwahati, where he possesses a printing machine used to produce the FICN.
Yes, that's one.
Yeah.
That's the true printing
Regarding
machine.
whether IO recovered from him, that is not mentioned. Only he possesses, Sahil possesses that, not yet.
আমার কারেকশন করে যদি ডিআরএম কারেকশন করে দিব আই নো ইট রিভিলস দ্যাট ওয়ান co-accused Sahil আমরা মিলাই দিব লাইন টু Sahil possesses one printing machine for the printing those
For printing those FICN.
fake currency. So, but okay, I have already reflected that
Yes.
those
Only he
that printing machine was not yet seized,
Yeah.
though it is stated in the IOS.
Obliged.
Huh? Ready with it.
My lord, offense is 108, my lord, abetment of suicides. Till today, 54 days, my lord, or 20 of June detail. There was another accused, two accused were there. He is already released on bail, my lord, on 7th. But what happened, my lord? The incident took place on 18th of June, and 1 month prior to the date of the incident, the deceased victim, my lord, is a mechanic, motor mechanic. He took my motor mechanic from my home, my lord, to repair. My motor was not working. He took my motor pump, and after 1 month, when I rang him, he's not responding, my lord. Then I along with the other accused, my lord, Rakesh, I went to his home, my lord. There, after charge, then I could find him. Then he told me that he sold this water motor pump. Then I told him that without my consent, you have sold it. Then some dispute took place. Then he said okay. Then I demanded money, my lord, 12,000. Then he said no, I cannot pay. Then he has as a security measure that he was given one scooty and one mobile phone, my lord, on 18, my lord. Immediately, but at night time, my lord, within 15 minutes, we have deposited the scooty and the mobile phone in that outpost, my lord, Vijayanagar outpost, Palasbori police station. But we do. At that point of time, another person came, my lord, Rajdeep Das. He told to the police station. He came that he showed that this scooty belongs to that person, my lord, not of that deceased victim, my lord. Then police, after verifying all those documents, that police returned that scooty, my lord. Then we returned home, my lord. Then we have written one complaint also about this incident to the police station. Next day, my lord, you can find that that victim he has committed suicide, my lord. The one suicide note was there from the FIR also something and forwarding report we have to find, my lord. This is the incident, my lord.
We have received the city lordship. It is true lordship that he has taken one motor from this person, and after he is it is not revealed that he has sold it or not, lordship. But one witness stated lordship that he, along with these two accused persons, he he came to his residence. Thereafter, he on the way he made this person that he made that this is person. Thereafter, they have taken the bike and the scooty and the mobile phone. That much is there also. And one suicide note was found along with him, lordship, and wherein it was mentioned that lordship, because of their torture, he has committed suicide. That is there lordship. And for that person, first lordship, it had been sent to the FSL report, whether that was his handwriting or not. For that first lordship, IO has also collected some notebook or handwriting from his residence, and it has altogether all these have been sent for FSL report. That the report has not been yet received.
Regarding the handwriting.
Another accused is released on bail, well. The other accused, well, he is already released on bail on the same footing, well.
But Ada is not on the same footing because lordship, he is the main person for which the money is in between them. Transaction is in between them. All of us.
Other two accused persons accompanying you. You are the main.
On the accompanying.
Your motor,
Till today, 54.
your motor is,
Yes,
your
my motor is
he took for your repairing.
till today 54 days, well.
Heard Mr. Ardal, Children Council for the petition. And also heard Mr. P.S. Rockford, Children Additional BP, appearing on behalf of state respondent. This is an application under section so and so in conditions. Next, right, the subsidy receipt, it is submitted by Mr. Das that the present accused petitioner is innocent and he has not committed any such offense alleged in the act. So it is a fact that one motor, water motor machine was given to the deceased for repairing, but in spite of his repeated requests, he did not return the motor pump. And on inquiry, it has come to know that he had already sold the motor pump set to another person. On demand, the accused given his scooty and one mobile phone, but those were brought by the petitioner along with his co-accused to the police station. And when another person came and claimed the scooty to be his own. Accordingly, the police returned the scooty to that said person, and thereafter came to know that the petitioner that the victim committed suicide. There is no such act, and there is no such abetment by the present petitioner to commit suicide by the deceased and deceased. More so, the petitioner is in custody since last 54 days, and the other co-accused persons have already released on bail. Considering this aspect, also the petitioner may be released on bail. Next one, Mr. Rockford, the additional PP submitted in this regard. That is a fact that the motor machine was water motor machine was given to the present petitioner for repairing, but on demand, the present petitioner along with two other accused person had taken away his scooty and the mobile handset, and thereafter the petitioner committed suicide. However, a FSL report is yet to be collected by the IO to confirm in regards to the handwriting of the deceased. Hearing the submission made by learning counsel for both sides, it is seen that both sides I have both sorry. After hearing the submission made by learning counsel for both sides, I have also diary, and considering the materials available in the case diary and the other aspects of the case, I find that further custodial interrogation may not be necessary for the purpose of investigation, as I got sufficient opportunity to interrogate him in custody. In view of this, without going into the detail of the merit of the case, only considering the length of detention, so and so. More on that. To whose satisfaction this one is for?
Abidgaon.
The place of the
Abidgaon.
CGM who?
Kamrup pilot.
Kamrup Metro?
No.
Metro or
Rural pilot.
rural?
Abidgaon.
Kamrup, to the satisfaction of CGM, Kamrup.
Regarding 9, 10,
Okay, you are granted.
regarding 9.
Hmm?
9, 10 and 11 lordship, may kindly fix it on any other day lordship because I have to go.
Day after tomorrow.
No, we don't have any date.
Any day, lordship.
Okay, they are right. 19, 11. He's saying that there may be some meeting and all on 14th also. In that case, 18 also there are fixed matters. At best 19 to 7. You are saying 19. I don't mind. Happy to do it. 18 is already, there are some matters. Maybe on 19 and 19 will do. 19 on the matters be listed. 9, 10, 11.
19, 11.
18.1. Sorry, I got 19. You are retaining the case that
Here in this case, LCR has come.
sorry, it's TCR. TCR is there only. Okay. Oh, it is a charge sheeted case, na?
My lord, IPM 24, my lord.
We'll see.
Lordship, one last opinion, the city was.
Yes.
I have received the case there, madam. Can you show the statement? One eyewitness of the dinner. Kindly please.
You want to submit anything, Mary?
My lord?
You want to submit anything?
Yes, and my lord, the fact is that already on last occasion I had partly submitted. Now again, I want to take you to the brief of the matter. Basically, here the section 76, 79 and 351(2) is attracted in this particular case. And on the day of the incident, as already stated by the accused petitioner, like on that day of the incident, he had gone there along with his friends. They were there present at that place, and he went there actually to take bath in the river. And this particular victim, she has stated in her the FIR that while she was coming through that route nearby the river, she was confronted by this particular accused petitioner who had suddenly encountered her, and then with an intent to disrobe and to carry out any sexual act, he went towards her. Now, here the petitioner says that that particular incident had not happened. What has actually happened is that there was some civil dispute actually. Like this victim was owing some money against this petitioner. Now, what has happened on the day of the incident, the victim's brother was also present at that point of place where this petitioner had gathered along with his friends. Now, they had some little bit of quarrel, and in that particular point, this particular brother, he knew about that fact that some money was owed by his sister. And then maybe it was at that point of time he took some chance, since they were in a particular environment where he could go and he could make some sort of case against him because of the fact that his sister was owing some money. So he went and he informed his sister, and the sister came, and at that point of time they confronted. So that was the version of this petitioner. Now, whatever she has stated in her 184, that will be that lordship will peruse. But our fact is that this matter actually no such incident had happened where these ingredients of the sections can be attracted. Basically, these are all up to 7 years. 76 is up to 7 years. Now, here the police in their forwarding report, they have stated that there is a chance of public law and order situation may take place. And and for that, 35(3) was not issued. Though it is a mandatory proposition as laid down by the Supreme Court that in any case up to 7 years, 35(3) should be issued. And the petitioner has cooperated. It is not like that he is not cooperated. He himself, he would have gone to the police station if any notice would have been issued. Now police have directly arrested, and it is a matter where a little bit of high-handedness on the part of the police, because what has happened is that this petitioner and the police they may have some sort of earlier encounters. So it was a case against the petitioner which was basically made by the police with the help of the informant victim. And the informant victim was known to this person. It is nothing like she was not known. Now, regarding the attraction of the ingredients, it will only come after thorough investigation and as per also the statements and the materials that is available. Now, I am behind bar. This petitioner is behind bar for 23 days now. So already in the forwarding report, police have stated no police remand. They did not wanted any police remand. They directly wanted for custody. Now, if it is in the custody, it is the prerogative of the IO to go there and to interrogate him in the custody. So how many times he have gone? So it can be only reflect through the CD, whether he has gone and whether he has cooperated or not. Now, in this case, since it is up to 7 years, this is a fit case where he can be enlarged on bail and he is going to cooperate with any strict conditions that can be imposed by this Honorable High Court. That is the petitioner's submission at this point. And regarding the ingredients, it is still debatable whether exactly such incident took place or not. So it can be only revealed through the city.
I have the submission, my lord. Here, statement of the victim, my lord, along with his mother, uncle. Eyewitness, both of the statements are under 183 statements available, my lord. Such may be in 183, my lord, implicated the accused victim. Uncle's statement is also there.
My submission is that, my lord, in 183 statement of the both victim and, my lord, her uncle, my lord, eyewitness, my lord. Supposed to be eyewitness, my lord, both of them implicated, my lord, what he has done, my lord. His conduct, lordship, my lord, on his conduct and intention, my lord. That is also to be considered, my lord.
Absolutely, my lord.
Otherwise, if the, my lord, eyewitness or uncle is not there, my lord, what will happen to her, my lord? That is also one of the aspects.
My lord, considering my stay in custody now, 23 days already passed. Already, if any interrogation required, then I was there. So how many times the police have gone and interrogated me? And this is also not like absolutely it was a heinous crime. Yes, though 76 says that the ingredients directly says like disrobing is there. Now the fact is that through the FIR, when we go through the FIR, it shows that he has disrobed himself and then he has went towards the victim. Now it is a matter of investigation whether it was really that particular incident and the ingredients extracted or not. Because of the fact that there was
But
the
they have
witnesses.
submitted, I have heard you,
Yes,
that they also. I have
Oh,
heard.
yes, my lord.
But the question is that your victim statement is very bad. The way you acted or the way you behaved with her is very bad.
My lord,
It
in
seems to.
183, in 183.
Yes, 180. 183 is very.
My lord,
Suppose suppose as they have submitted there is a civil dispute or monetary
Yes, yes.
dispute was there.
She did not mention.
It's not anything is there. Even in independent witnesses, suppose it's not even a single whisper in regards to any monetary dispute.
Okay, my lord.
Because
Like there are
the
independent
person-
witnesses are also there, my lord.
Hmm.
Okay, okay.
Independent
Okay.
witnesses are also
Okay.
there.
So
from
that
their
is important.
witnesses-
Yes, yes.
From
Independent.
their witnesses,
But none of the
it's
said
not
about
okay,
the
none of the
civil
witnesses in a single whisper also there that there was any monetary or any dispute was there. It's not here. Nothing is
yes,
there.
yes.
Or one thing just to tell us that do you have anything to say to prove that there was any monetary dispute? Was there any
Documentary
documents?
evidence at this point of time we have not yet received that document. But if it is anything is there, then we can annex it.
Because you have submitted that there were some
Yes, yes,
monetary
yes. It
issues
was
were there,
absolutely.
especially with the victim.
Yes, yes.
If there is there, then there might have some
Yes, then we'll
money
have-
received and all anything.
Absolutely,
that kind.
absolutely. Yes, there
But
needs to
that,
be at
that
least
you have
some
not annexed anything.
reflection of some contract, at least.
Pardon?
No, there has to be some reflection of contract, like there some money or anything.
Hmm.
Yes.
That is
Or
that
if
is
any
not there.
witness
You
would have
could not
also
furnish anything.
whispered that yes, there was some money angle was there, then it would
Yes.
have been a absolute. Now our point is the ground is that since 23 days I'm behind bar, I'm going to cooperate regarding kindly if lordship permits, kindly peruse to page number 22 of the petition annexure B. There they have objected basically, my lord, bail objection. In that here they have stated point number 4, and that any bail might lead to disturbance of public order, loss of faith of public on justice system. Then point number 5, as the nature of the case is very sensitive, the accused person is involved in the serious case of woman-related crime. There is anger among public for doing such an act in this area, and if it is enlarged on bail, the public may go for agitation, demonstration, which might have serious law and order implications. And 6, it is very possible that the accused person will not cooperate with the investigation agency and he may abscond to avoid police arrest. Therefore, 35(3) BNS notice is not applicable against the accused person. So these are the mainly reasons they have stated. Under actually it should come under 35(6) that because 35(6) directly says that you cannot automatically arrest only unless there is some cogent reason. So these are the reasons we take it. Now the fact is that it is not that point where this law and order situation directly comes. If I go to the case. And second point is that he's not going to evade the arrest. He's already now he's under custody. So he has not evaded arrest. He has been arrested. So he's not going to.
Those are the ground that why the 35(3) was dispensed with. That ground only.
Yes, so these are the main grounds. So we are just going through the grounds only that he is going to completely cooperate. He's not going to hamper or temper. He's not going to even influence the witness if required strictest of conditions. Because of the fact that this is only up to two sections are there, 3 years and 2 years, 351 to 2 years, and this is 3 years. Only one is up to 7 years. So considering that fact and that it could have been taken care of by 35(3) actually. Now the fact is the police is having some issues with him, maybe. So and at the same time, the statement has been recorded and the statement reveals. So it is a case which needs more investigation because charge sheet is not yet filed. So in the meantime, I will only pray that he should be enlarged with some conditions. If it's strict conditions, that he's not going to influence, he's not going to abscond, and he's going to
Yes,
cooperate.
vote against submit.
My more submit is I have already submitted my lord in one it is statement my lord. Lordship also pointed out my lord. That's very big what he has want to done my lord.
Okay.
And
Heard Mr.
If-
W.R. Mehdi, the learned counsel for. And also heard Mr. B. Sharma, the learned additional PP, appearing on behalf of citizens. This is an application with constituency in connection with CD receipt, Ferris receipt. It is submitted by Mr. Mehdi, the learned counsel for the petition, that the accused petitioner is innocent and he has not committed any such offense as alleged in the FIR. There was a monetary dispute between the victim and the accused petitioner, and he want to ask the money or no? The money
No,
was
no,
not
she was
I mean-
yes, she's a married woman also.
money, and the day of incident also, there no such incident had happened as stated in the. Further, he submitted to the cases registered under section 76 of BNS, but there is no such ingredients to fulfill. There is no such ingredients to affect the section 76 BNS. Rather, it was as per the allegation, it was the accused who disrobed himself at the time of incident and not the victim. Mr. Mehdi further submitted that accused is in custody since last 23 days, and thus the IO got sufficient opportunity to interrogate him in custody. Mr. Mehdi also submitted that the cases, the sections which were registered, the section under which the case is registered are all below 7 years, up to 7 years, and hence it is the duty of the police officer to provide, provide with the notice under section 35(3) BNSS. But the reasons which have been mentioned in the forwarding report is also not sufficient to dispense the notice under section 35(3) BNSS. However, the petitioner is ready and willing to cooperate with IO in further investigation of this case. It is granted with a privilege. Mr. Sharma, the learned additional PP submitted in this regard that there is sufficient incriminating materials brought by the victim as well as some of the witnesses who saw the incident. And considering the materials available in the case diary, the petitioner is not entitled for bail at this stage. The further submitted that the victim had explained as to how she was misbehaved with the intent to commit rape on her, and in that context, the petitioner himself disrobed him and came towards the victim with the same intent. Mr. Sharma accordingly raised objection, submitted that the petitioner may not be released on bail stage. But during this submission made by learning is that considering the metrics available in the case diary, especially the statement of the victim, I not find it a fit case to allow the accused to go on bail at this stage. Further, it is seen that the IO made some sort of explanation regarding the dispensing of notice under section 35(3) BNSS, and considering the entire situation of the situation and circumstances of this case, it is seen that the arrest of the petitioner may be required. Immediate arrest of the petitioner may be the immediate arrest of the petitioner may be the requirement of the case. Considering all the aspects of the case, they not find it a fit case to extend the privilege of the present petitioner at this stage, and the same stands. Your petition stands with.
Complex.
21.
None appears on call for the petitioner. What is the position of 21? Are they were on interim? No. The interim was there. Was not there. The wrong submission. Yes, interim was not there. এইবিলাক কথাৰ কাৰণে দিগদাৰী ইহঁতৰ ইয়াত আকৌ ইণ্টাৰিম আছে ইয়াতো ইণ্টাৰিম আছে ইণ্টাৰিমটো আছিলে CD not received or received? Not received. None appears on call for the petition. CD not received. Issue reminder. Is the matter accordingly? You need any date here or after 1 week? List the matter after 1 week? No, that will again be a problem. 27/8. List the matter 27/8. Interim be extended the next day.
And that fix on
27/8.
Treasury was called for.
Yes, 22 days.
CD also not received, man. He also not.
CD not received. But I think you are not on interim.
No interim, no interim.
And when can be fixed, Sharma?
My lord, after your program, Vishwanath, Chutia PSP.
27 same day.
27?
I play interim, my lord.
Sorry. CD not received. Issue reminder 27.
23.
Blood.
May I please, the lordship, 482 will application, case value was.
The position here.
CD received.
CD received.
From the FIR is in page 10, my lord. It's a case of my lord, house trespass and my lord, assault or use of criminal force with intent to disrobe, my lord. So totally false case, my lord. Actual act is that, my lord, it's a season of rice cultivation, my lord. The petitioners, the informant's husband took my plow, my lord, because his plow was broken. And on that day, my lord, the petition, informant's
Plow means?
plow means, my lord, in Assamese, it's nangol means.
Nangal is plow.
Yes,
Okay.
nangol. My lord, the informant's husband took it, my lord, from me. And on that day, my lord, he informed me, the informant's husband informed me that you can take back your plow from my house, my lord. Accordingly, I went and I took my plow from the informant's outside, my lord. But in the meantime, my lord, I did not inform her, my lord, informant, my lord. That is why, my lord, some were heated argument was made, my lord, between us, my lord, and all our neighbors were present, my lord. That is the actual fact, my lord. But the allegation is totally false, my lord. And my lord, probably, my lord, in this case, my lord, custodial, my lord, interrogation for the purpose of investigation may not be required, my lord. This is my Harmut submission, my lord, before you, chief, my lord. I have stated, my lord, actual fact in my petition, my lord. That is, my lord, paragraph 5, my lord. It's the actual fact, my lord. Nothing has happened, my lord, as alleged in the affair.
Yes, Sharma, any other?
My lord, my submission is there, my lord, although in 161 it is similar, Lordship may kindly peruse that what is happening, my lord. One witness is also there, my lord. When he returned back, my lord, from our house. my lord.
So Mr. B. Burago.
Yes.
Heard Mr. B. Burago, return from. And also heard speech, return education. Yeah, very long, yeah. Section 20, submitted by Mr. Burago that present accused petitioner is innocent. Nothing had happened as well as in the actual fact of it is that the husband of the informant took the plow from him with an actions to return it. And thereafter, after plowing of his land, the present petitioner asked the husband of the informant to return the plow. And he also told that it can be free from his house. Accordingly, the petitioner went to the house of the victim and took his own plow when the informant, the victim raised halda, and there was some heated argument on that. Except the said incident, except the said incident, nothing had happened as alleged in the end. However, the petitioner is ready and willing to extend his cooperation in further investigation of this case if he is granted with some information. Next para, Mr. Sharma, the learned additional fee submitted in this that the victim, the statement of the submitted that there are sufficient incriminating material against the present petitioner, especially victim described in her statement recorded on section 183 BNSS as to how she was sexually assaulted. Next, hearing the submission made by the counsel for both sides. I have also perused the case diary. After perusal of the case diary, considering the materials available in the case diary, statement made by the victim, and other aspects of the case, I find that custody interrogation may not be required in the present case, and accordingly, I find it is to extend the privilege of pre-arrest to the present petition. So, okay, your petition. Your petition is allowed.
Highly obliged.
May I please, Your Lordship?
My lord, sitting not to see, my lord, they are interim, my lord.
That interim may be continue and he was appeared before the IO and his
This statement is
statement has
already
been
recorded.
recorded.
City not to see, you should remind. Yes, when it can.
My lord, 9th of September.
9/9. Interim be continued till next year. Your interim will be continued till 9th of September, fixing it for the city.
Obliged.
Yes, my lord. Did you receive me?
Are you on interim there? No.
Yeah, no, my lord.
We're not on interim.
First of all, my lord, the informant being an illiterate, he did not retain the FIR, my lord.
Informant.
Yes, my lord.
It was written by someone else.
As somebody third persons, on the basis of somebody third person's instigation, the informant
You are
lost his
going
FIR.
to say
after
there
2
on
days.
instigation only the FIR was lodged.
Yes, after 2 days, my lord. But the reason for delay, they have not written in this FIR, my lord.
Hence, that as such, the in allegation of the FIR, contents of the allegation FIR, he did not know, and all the allegation, my lord, are manipulated. Not only manipulated, my lord, it's a fabricated also, my lord.
Yes.
There is no proof, my lord.
No,
that
proof
he-
will come later on. Now say.
My lord,
the
first of
allegation.
FIR, my lord. First of all,
Come
FIR, my
the
lord.
FIR first.
That matters are relevant at this stage, my lord. Only FIR, my lord.
He was.
My lord.
If
Beaten, he was
is
beaten,
there any
thereafter, my lord.
compromise with you?
No, my lord.
No, you are saying that he was illiterate. He is not aware of about the contents.
Yes, my lord. Yes, because he is
This
after.
will come later on, but now
My
the
lord.
question is, what is the allegation?
First of all, FIR, my lord. First of all, FIR.
What
Yes,
is
my
the
lord.
allegation?
Allegation is, my lord, he is demanding rupees 50,000 as per FIR, my lord. And already he paid 15,000, my lord, as per the allegation, my lord. But there is no proof of, my lord, he has given the 15,000, my lord, on the basis of the FIR, my lord.
I will see to it now. Now, as per you, what is the case?
Yes, my lord.
Yes. What is the case?
Case is, my lord, there is some transaction in between petitioner and
Monetary transactions were there.
yes, my lord.
Mhm.
Earlier transaction was also there because they have he has visited the informant visited in our village, my lord. Sometimes in dealing with some business purpose, and that's why there are some area amount when I have he did not pay. So when I asked about the earlier payment, then there is some conflict arise, and on the basis of that there is some confliction, and he told return back to their home. Then the third person instigate to lose the FIR. This is the facts, my lord.
My lord, may I?
I
My
just
lord.
could not follow. In
Lordship,
fact, there was
Lordship, my
a
lord. This is not clear from his, my lord, submission, my lord.
submitting. I
May I read, my lord, FIR, page 15, my lord, particular, my lord.
Yes.
What is the, my lord, the text, my lord?
Yes.
Page 15, my lord. সন্মানবোৰ নিবেদন এই যে যোৱা ইংৰাজী 24 তাৰিখে ৰাতিপুৱা অনুমানিক 54 বজাত মিলন বজাৰৰ ওচৰৰ পুখুৰীৰ পৰা মই পোনা মাছ 8 কেজি চাইকেলে লৈ 2 নম্বৰ দৰংগাবাৰ গাঁৱলৈ যাওঁ আৰু বাটতে 1 নম্বৰ পদকীয়াই মোক বাইচাইকেলখন ৰখাবলৈ কয় আৰু মাছখিনি চাই প্ৰতি কেজিত কিমান দাম লাগে বুলি সোধাত মই প্ৰতি কেজিত 250 টকা বুলি কওঁ তেতিয়াই 2 নম্বৰ পদকীয়াই 200 টকাত প্ৰতি কেজি পোনা মাছ পায় বুলি কয় আৰু পোনা মাছ থকা ডেক্সিটো নমাবলৈ কয় লগতে 3 কেজি মাছ জুখি দিবলৈ কয় আৰু মই জুখি দিওঁ তেওঁলোকে মাছখিনি লৈ পুখুৰী পাৰলৈ যায় কিন্তু পুনৰ মাছখিনি ঘূৰাই আনি আকৌ এবাৰ জুখিবলৈ কয় পুনৰবাৰ মাছখিনি ওজন কৰাত আনুমানিক 500 গ্ৰাম মাছ কম পোৱা যায় এই অজুহাত লৈ পদকীয়াদ্বয়ে মোক গালি গালাজ কৰি লগতে মাৰধৰ কৰি গছত বান্ধি থয় লগতে মোক 50,000 টকা দাবী কৰে অন্যথা প্ৰাণে মৰাৰ ভাবুকি দিয়ে মই প্ৰাণৰ মমতাত মোৰ সম্বন্ধীয় কুৰ্মাক ফোনযোগে মাতি আনি কুৰ্মাৰ মোবাইলেৰে 2 নম্বৰ পদকীয়াৰ মোবাইলত জিপে যোগে 15,000 টকা দিওঁ পইচা লোৱাৰ পিছত তেওঁলোকে মোক মুকলি কৰি দিয়ে আৰু লগতে পুলিচৰ আগত এইবোৰ কথা অৱগত কৰিলে প্ৰাণে মৰাৰ ভাবুকি দিয়ে This is the real fact, my lord. What is happening, my lord?
Yeah.
Only for the mass of Pune, my lord. Mass of Pune, my lord. And if you have any submission, the after, my lord, CD reveals, my lord. Some witnesses are there, my lord. And it was in viral also, my lord. Some photographs also viral, my lord. Here, assaulted and he was roped in the tree, my lord. In their house, my lord.
Yes, my lord.
And from the statement, it reveals, my lord, some eyewitnesses are there, my lord. Both of them father and son, my lord.
These two petitioners.
My lord. And photographs also there, my lord.
Lordship seen the PDF photograph. Only for that he was roped by both of them, my lord, in that
My lord,
my lord.
before come to the point, my lord, may kindly be see the page number 4 in my bail petition, point number 4. Here are not only the father and son, there are some people are gathering also there. So who were holding and tied up, nobody can say, my lord. Because people are gathering and he is also not only the payable amount to the petitioners, but there are some villagers he have to pay. So that's why while after long gaps, he visited to our village, then some people are also asked. And then they being a deceiver seen, then some people are tied up on the
What a
plank, my lord.
behavior to the such type of
But-
poor my lord,
But
businessman.
on the photograph, the father and son also not there, my lord. In front of our house, then he told the village, my lord, villagers that they have asked me the 15,000 rupees.
So one hand, you are saying
Yes.
that only monetary transactions were there and false cases lodged against you.
Yes,
under
my lord.
jurisdiction of the third person.
Yes, my lord.
Now you're saying that yes, he was tied, he was roped.
In front of their house.
I'm not my
We have your house. Now you are saying your version is different now. One hand, you are saying that only monetary transactions were there and that's why
Yes, yes, yes.
when on demand, these false cases
Yeah.
were under the instigation of some third person.
Yes, my lord.
Now you are saying that no, he was tied and the villagers are the villagers.
As
were
per
also
FIR,
tied.
my lord. As per FIR,
No, now you
we
are saying
not
that
tied up.
villagers were tied. Now we are saying that in the presence of villagers, the person was tied on the tree in front of your house.
We are not threatening, my lord.
No, front of your house.
Yes, yes, in front of our house, my lord.
Then what you're saying then?
And other people also gathering, my lord. There are people are gathering, my lord.
Just tell us, Sharma, in
Right.
this case, a custodial detention will be required or not?
My lord. My lord, my submission is that, my lord, what that they have done, my lord, only for the some my lord, business, because they have taken the law in hand, my lord. They have taken the law in hand, my lord. They have robbed the my lord, such type of poor my lord, businessmen, my lord. They have daily come in our village also. They came in the morning hours. Masor puna biki korbo ahe. Then they in the evening time they return back. In the next day they also again come, my lord. But only for that 500 grams, my lord. And it was when they taken into the my lord, pond, whether they have thrown in the pond or not, my lord, that is different thing. My
If it is genuine, my lord, then he
then
should have
only
to
for
lodge
that
the FIR.
purpose, my lord. He was robbed and assault, and thereafter demanded money 15,000.
No,
They have
there is no proof, no medical ground, my lord, medical proof. Because if it is genuine, my lord, then the victim should have to lodge the FIR on the very day, my lord. Because it is lodged after 2 days, my lord.
all that photographs also become viral in
Somebody
the social media. Also.
organization, there is some organization on the basis of some pressurized to lose the FIR. You have to lose the FIR.
Your good
Then
name?
he lost the
Your good
FIR.
name?
It's Sidas, my lord.
Heard Mr. H. Das, the learned also. Heard Mr. P. Sharma, the learned additional PP appearing on behalf of citizens. This is an application under section so and so in connection with this right. City receipt. It is submitted by Mr. Das that the present request petitioners are innocent. Petitioners are yet many petitions. Yes, two petitioners are innocent and they have not committed any such offense as it is in their file. It is a fact that there was some monetary transaction between the accused and the victim, and when the money was asked, there was a quarrel, and some other villagers were also present and during that time. And only on the instigation of some third person, the FIR was launched by the informant after with 2 days delay. But delay is not explained in the FIR and not explained in the FIR. However, the petitioners are ready and willing to cooperate in further investigation of this case if they are granted with the privilege of pre-hearing. Next one, Mr. Sharma, the learned petition PP submitted in this regard. The from the materials available in the case diary reveals that these two petitioners tied for businessmen only with the allegation that there was 500 kg of 500 of a kilo, 500 grams of fish seed was lesser when it was sold to the petitioner. In that aspect only, both the petitioners tied the tied the victim on a tree and assaulted him badly. Accordingly, he submitted that the petitioners took the law in their own hand, and hence custodial interrogation may be required for the purpose of investigation. Next, considering the entire circumstances of case, the statement made in the materials available in the case diary, I find that one opportunity may be given to the present petitioner to appear before the eye and to record their statement. In view of this, both the petitioners are hereby provided with interim Okay, you will be provided with some interim protection, appear before the IO and place your record your statement.
Yes.
We are listing it on 9/9.
Right.
Within 7 days, you appear before the IO and record your statement.
Obliged. Obliged. On return the case then.
Yes, sir. Call for the updated one.
I don't like the interim is it? No. Obliged.
Yes. Yes, 26. What is the position?
Right. Item number.
Perhaps CB is not there.
26, no? 26. CD notice in, they are interim.
CD not received, issue reminder. Yes, when it can be listed. Make it on September.
Mile.
February.
7/9.
7/9.
No, no, man. 10th.
10th of September.
Highly obliged.
10/9.
10/9.
Interim be extended till next.
Please, my humble prayer password matter for the day only. Shiv, any day.
LC has come not.
LC is no.
LC received not in this case. I have confirmed the LC receipt. Injuries are simple loss. No such serious implications are also there from the witness part. Just some assaulting part there.
Now, what is the stage of the case at that?
Lordship, charge sheet is submitted.
Charge is submitted.
LC.
Whether evidence.
That's why LCR call for your lordship.
Yes, that's true. Whether any evidence recorded? No.
Nothing. No. Page 38 and 39, the medical report of my petition, I have annexed your lordship certified copy.
No, anyway, no, what do you want to submit that today? Yes, today.
Today, lordship.
Why?
Today, lordship.
No, today will go 3-4 days because we don't have any dates. Today will go for 20, 21, 22, 20, I don't know.
Today, I am
Will be
ready.
okay.
Today, lordship.
You want to argue the matter today?
Lordship.
Oh, yes, then I
The case is shown as absconder.
You are shown as an absconder.
Absconder, your lordship.
You are shown absconder charge sheet.
Lordship. FIR is page number 11, your lordship. It is a quarrel of two brothers, your lordship, and sons. One brother, your lordship.
Own brother.
One brother. Regarding land dispute, your lordship.
FIR is at page?
Page
Yeah.
number 11, your lordship.
Oh, sorry. So, anyway, land dispute was there. Okay, then as per you. And is registered under which section? Yes.
Trespass section, your lordship.
118 is also there. 109 is also there.
171, 109 is attempt to murder, your lordship. Others are available, your lordship.
Oh,
All others are.
118 is available.
109 is non-bailable, your lordship. Others are bailable, lordship.
1181 is also available.
Lordship. 115, 126, 61.
118, say 118.
11.
118 is also available? I don't think so. I am not so acquainted, but I don't think so.
115.
Any, what is your case? This is a dispute between two brothers.
Lordship, charge sheet not submitted under section 1180, Lordship. Charge sheet
Okay.
submitted under section 61 close 2, 126 close 2,
61,
close 2, which is bailable criminal conspiracy, 126 close 2,
126.
close 2, wrongful restraint, that's also bailable
126 clause 2.
close 2.
Okay.
115 close 2, Your Lordship. That is
115.
voluntary causing hurt, that's bailable.
Huh.
109 attempt to murder, Your Lordship, that's
That is
non-bailable.
not bailable.
296 obscene song, Your Lordship,
Hmm.
bailable. 351 close 3 criminal intimidation, Your Lordship, and 3 close 5 common intention.
So these are the sections under which the case
All are
is
bailable, Your
charged.
Lordship, and 109 is not bailable. Attempt to murder. Where is injury is simple, Your Lordship.
Injuries are simple.
Simple. Page number 38 and 39, Your Lordship. Annexure F and Annexure G, Your Lordship. Page number 38. Annexure F, may kindly.
This is medical report of the victim.
Victim, Your Lordship. Blood. Physical assault. Physical assault at their own residence on Swens. There's also physical assault. Physical assault. Same. Ashraf Ali, Azur Rahman. Blunt, type of weapon blunt, nature of injury simple.
Basically land dispute.
Lordship.
So why didn't you cooperate?
Lordship, after filing of charge sheet, Your Lordship, I will post before
No,
the
no,
land.
no. Before filing of the charge. At the time of investigation, you didn't cooperate with the IO. For that reason only you were shown as an absconder. Why you didn't cooperate?
Lordship, I was submitted charge sheet as absconder, Your Lordship, but
Oh,
I
that's
was
what I'm
not
asking.
absconding,
Why
Your
you
Lordship.
have not
Submitted.
cooperated? Why you have not cooperated? What was the reason?
There is a section of 109 non-bailable, Your Lordship. I filed bail petition 3 times, Your Lordship, in the lower.
No, no, no. We are not on there. You were shown as an absconder. That means what? That you have not cooperated. I'm asking why you have not cooperated. Why you not extend your cooperation during investigation? That's what I'm asking.
Bail section is 109, Your Lordship. Actually, I am reset.
109 will come later, and I'm asking during investigation. You have not cooperated. That's why you have shown as an absconder.
Lordship.
109 will come later on. It is a charge-sheeted section. There may be apprehension of arrest and all, or whatever you have not, may not appear before the London trial court. That can be understood. But you have not cooperated in investigation.
In FIR also 109 is there, and that's also apprehension of arrest.
Oh, you know the FIR.
Lordship.
Oh, in spite of knowing all this, you have not cooperated. Oh, you know better that there is
There
109.
is a quarrel took place, Lordship, at the resident.
Oh, that means everything is known to you.
Lordship.
You are aware about the case.
Lordship.
Oh, very nice.
Because I filed a bail petition also, Lordship. Annexure C, page number 32. Lordship.
Against them, summons. Against you, summons issue.
Summons not issued till date, Your Lordship. Only
What
charge sheet
issue?
submitted, Your Lordship. Only charge sheet submitted, Your Lordship. Summons, we have not received any summons.
Till date, you have not received any
Not
summons.
Maybe we received in few days, Your
Maybe,
Lordship.
sure.
Maybe.
Because it is a sessions tribal, I think.
Session tribal. Lordship. Subsequently renumbered as PRC, Your Lordship.
Yes.
Because
What is 3R events? Huh?
Injuries are simple in aspect. Cases are not so much serious by the I have take market or something like that.
Your earlier bail application rejection order where you have annexed it?
Is number 32, Your Lordship.
32.
32. Relevant portion is page number 33, second para. Preliminary injury report on the basis of preliminary injury.
No, your rejection order. This is your rejection order.
Lordship. Page number 32, relevant is page number 33, second paragraph. I have perused the case diary. The preliminary injury reports furnished from the Pokazar Medical College and Hospital shows serious injuries sustained by the injuries victim. Further materials collected show the injury were hit by the rod which resulted in serious injury.
So where from this court found that it was a serious injury?
It is a preliminary injury report, lump sum, your lordship, not final, your lordship.
How?
No, because the medical legal report is dear lordship.
Medical legal report says this the simple injury by blunt object. But no, the court observed that it's a very serious injury.
Page number 34, your lordship, after filing of charge sheet, your lordship. Page number 34 at bottom, your lordship.
They intend to cause death and all. That's why.
There is a IO informed that WT message that charge sheet has submitted in the case.
Okay.
That's
Okay, I'll
right.
pass the order.
Lordship.
CPI is a proof. আপনি খবরটা বলেন whether it will be from here or there. No, D Mutundar আসেনি। যাতে একটু তারপর থাকুন এইটো বৰ বেল এইটো আপোনাক কোনোবাই কৈছে নেকি কিবা কোৱা নাই ন ডি মজুমদাৰ আছে কি বা হয় এইটো গম নাপাওঁ কাম কৰক মই ভিতৰত ৰেডি কৰিব দিম এইকেইটা আই যিকেইটা আছে এইকেইটা কানেক্টেড আই হয় আইকেইটাতো আপোনাৰ তেওঁলোক নাই কিন্তু যেটো মেইন ইলেকশন পেটিশন মজুমদাৰ নাম দেখা যায় in connection with that election petition only those eyes are there apuni eta information lobo whether any senior advocate mojumdar hok ba kp pathak hok teloke whether they are going to appear jodi nohoy kuna thakle jehna moi chamber eto olop time lobo pare ba kp man time order korom moi chamber ready korbo Here, Purnachural politics. Yes.
My lord. My lord, this.
88, 2025.
My lord, this bail application, my lord. Earlier, my lord, this bail application, earlier, the bail granted to the alleged accused person was cancelled by this honorable court, my lord, in the criminal petition, my lord. Basically, on the ground that the earlier occasion, my lord, material fact, my lord, material evidence, my lord, that was not examined and considered, and solely on the basis of the age of the accused person, as accused person was 72 years at the time of hearing the evidence, considering the bail application, and only 3 witnesses were examined, my lord. On that ground, my lord, bail granted by the alleged accused person or the trial court on 20 June 2024 was cancelled in the criminal petition judgment and order dated 3rd June 2025, my lord. The cancellation order is at page 26 and paragraph, my lord, last part 48, my lord. 26 to 48, my lord. That meant, my lord.
Yes. Last paragraph, 48.
Yes,
Yeah.
my lord. My lord, well, disposing of the cancelling the bail application, my lord, on the ground that only the material, the fact which is to be considered was not taken into account, only on the basis of age fact it was granted. Therefore, the bail was cancelled with direct giving liberty to the alleged accused person to again approached before the trial court and move fresh bail application, upon which the trial court would consider the matter on independently, my lord, fresh, my lord. This was the case, my lord. This was the direction issued by the passed by the my lord, my lord. Basing on this, in compliance with this judgment, my lord, direction, the alleged accused person, my lord, surrendered before the trial court, my lord, on 17 June 2025, my lord, at page 49, my lord. At 49, my lord. After having surrendered before the trial court, my lord, fresh bail application was moved.
Yes.
Page 49 on surrendered on 17 June 2025, my lord. And subsequently thereafter, my lord, fresh bail application was moved on 26 June 2025, my lord, as directed by the my lord, my lord. At page 50, my lord, see, page 50 is the bail order passed by the Learned Trial Court on 26 June 2025, my lord. In the bail order, my lord, although there's nothing, any incriminating material, even it is to the extent that I observed that the whosoever the witnesses have been examined, my lord, material witnesses have been, there's nothing, any adverse deposition has been made against the alleged accused person, my lord. However, my lord, since the earlier bail application has been cancelled by the Learned in this before this by this honorable court, my lord, considering this aspect, my lord, my bail application was rejected, my lord. Without considering the all, because as of now, at the time of hearing bail application, my lord, altogether 14 witnesses were already examined. That is material witness, madam.
Until 26/6/2025.
Yes, my lord. 1 to 14. And just now remaining is, my lord, hardly that is not so, my lord, only the official witness, my lord. Remaining witnesses, my lord, from 15 to 19, my lord. At page 56, my lord, the list of prosecution witness, my lord, is see. At page 56, my lord. Now remaining witnesses, only official witnesses, my lord. Officer in charge and DSP, this all, my lord. And now this older witness, my lord, 1 to 14, my lord, which the earlier they have projected it to be an eyewitness, my lord. None of them has made any incriminating statement implicating against the present alleged accused person. Even to the extent that which they projected to be eyewitness, they even clearly stated before the trial court that they did not even recognize that the alleged accused person, my lord. They have question of eyewitness, and there's no implicating against the alleged accused person, my lord. But despite of this all material, my lord, having, and there's no any incriminating material, any evidence implicating against the accused person, my lord. Thus, the bail application, my lord, filed subsequently by the alleged accused person was not considered, it was rejected, my lord. That's why, my lord, this bail application has been filed, my lord, before this court, my lord. As there's no any, my lord, any adverse even finding evidence, part is completed, my lord. Now accused person is in a custody, my lord. When the purpose of the granting bail, my lord, it is either whether there's a chance of them bring the evidence.
Yes, ma'am.
My lord. My lord, the basic
So you are
principle.
submitting that at present there is no such incriminating materials in the evidences of.
Yes, my lord, even on merit also.
Now 14 witnesses were been examined.
Yes, my lord.
14 witnesses.
Even, yes, even their statement, my lord, even the order, rejection order passed by the Learned Trial Court, it is in all my favor, my lord. They have on record, my lord. The so far evidence, witness examined, there's none of them they have brought any incriminating material. They have not implicated against me, my lord. And all the witness, whatever they have stated, 161, my lord, that's turned out to be different in the before the trial court when they appear, my lord. So therefore, there's no any, as of now, my lord, so far, all the material witness, they have nothing, any adverse statement has been made against my lord. So, my lord, in this, my respectful submission, my lord, when there's a amply clear, my lord, that all evidence brought on record, my lord, there's no any implication against the alleged accused person, my lord. The alleged accused person must deserve to be enlarged on bail, my lord. Even in the case of open and shut case, my lord, at least so far, evidence so far the bail is concerned, my lord, that is to be considered in different aspect, my lord. Different aspect in the sense whether if he is released on a bail, whether there's a chance of tampering with the evidence or not, or there's absconding, there's likelihood of absconding or not. But in the present case, my lord, alleged accused person, this is an old man, my lord, and he has been arrested on suspect, my lord, and all the evidence material, all that has been duly recorded, my lord. So, in my respect, my lord, he's deserved to be enlarged, my lord.
चल रहा है सर आइटम नंबर
Yes.
Your Lordships, now, in our new High Court, it was shifted only on 10, inaugurated on 10.
Yes.
And today speaks for Silver Jubilee celebrations. And our office is shifted just yesterday on everything is in first condition. All the our office record is in somewhere else. So I think managed just moment ago only out of packed this randomly packed files and all the codes.
So you are not in a
this-
position to submit anything of today or what?
Yes, Your Lordships, earlier criminal petitions for cancellation of the bail was a contested case. It was represented by the petitioner who is
No, that was there. The cancellation of bail, that order was passed in the under the criminal petition. That is there. Yeah, after
Yes.
the cancellation, it was an order was there that you surrender before the court and you are at liberty to file a fresh application. So in that basis, they have filed application and that has been rejected. So against
Yes,
that only
it is
now they have come with a fresh petition for this bail, consideration of bail. In that regard, do you
Yes.
want to submit, because that part has already gone. There was some observation why the bail was cancelled. Basically,
Yes.
so far I can remember that the order was passed only considering his age. Though the nature of character of the case was not considered, only the considering the age, that is the 72 years, the bail was granted without any further explanation or without any
ground
further.
on the ground of purpose also.
Yes.
Yes. So you know, say, as of now, what stage is at what stage it is pending before
Now,
the
there is two
trial court?
question. Now he is saying that because I'm here at principal seat, so we are not in a position to say this evidence part is also not before me at present.
Yes.
Now, as per Mr. Tagum, that the witnesses which has already been examined, they did not incriminate the present petitioner. That is his submission. And apart from that, out of 19 witnesses, 15 has already been examined, 4 remain.
14 has already been examined, my lord.
14 examined, only 5
Yes.
remain. Those are acquisition. That part is his. So now you want to peruse the record, etc., or want to submit?
Yes,
If you
I want to peruse the report because as of today, what stage is what actual present stage is still pending? How many witnesses have been? It is from only record we can to we will know.
My lord, in that case, my lord, as of that, my lord, the evidence with the examined, but that scan copy may be called for, my lord, fixing the matter of my lord, if my lord's convenience, can it be on 22, my lord? Because
22nd.
scan copy. Yes, my lord, 22.
22nd may not be possible because there are some matters fixed when we have already fixed on 22nd. So maybe on 23rd or 21st. Let it be on 23rd then.
My lord, 25th, my lord.
Wait, just a second. Huh? Oh, sorry. 23rd is a holiday. 23rd, 24th, and 25th are holiday.
Madam, we can have a 25th, madam.
Then we can have it on 26th, either 26th or 27th.
My lord.
Will be okay? So your petition is in custody since when now? 14/6, 17/6, he is in custody?
Yes, madam.
Okay,
It be on 27.
27.
Yes.
27 will be okay, Mr. Tagore?
My lord, okay.
Okay. Okay, people can hear that way. Heard Mr. T. Tagore, Delaney concept the petition, also heard Mr. Spencer, Delaney additional PP appearing for the state respondent. It is submitted by Mr. Spencer, Delaney additional PP that perusal of the TCR will be required to know about the deposition already made by the witnesses. In view of this, let the scan copy of the TCR be called for along with the CD, case diary, along with the scan copy of the case diary. Let the matter be listed on 27/8/2020.
Obligers.
Okay, we are listing it on 27/8/2025.
Madam.
And better, we also want that the case record. In fact, it may be sent by the through the registry, I think. We'll
Madam.
get it. We'll get it. Okay.
Obliger.
Oh. Now here, yes, I think.
Right.
This one here from the zero. Item 2 is fixed with this election petition. Mr. Mujumdar is appearing on election
Madam.
petition. You are for the respondent, I think.
And for the respondent return candidate, madam, possibly there is a fresh interlocutory application. And that is numbered as
165.
155.
Yes, 150.
Yes, Miss Anju,
165 of 2025.
165 or 155?
165. In the cause list, I find it is 160.
Yes, 165
Yes.
is it does.
Yes.
Yes.
Now that is.
Yes, Your Lordship.
The applicant is district election officer. If the council representing the district election officer is there, he will please, because we don't have a copy of this IE.
Why this I is for?
Possibly I am
May-
by my.
Yes,
Yes,
Miss Anju.
yes, please.
Lordship, this I application has been filed for shifting of EVMs, Your Lordship. Shifting of EVMs from Government Higher Secondary School to strong room of District Election Officer, Your Lordship. This is only for shifting, Your Lordship. Because EVMs election materials are kept in schools, one of the room at school building. So we wanted to shift the materials to own warehouse, strong room, Your Lordship. This is only for shifting, Your Lordship.
It's in that,
Because-
Mr. Mujumdar, you want to peruse this one or?
No, possibly we are not very much concerned with it. If they want to simply shift from one place to another for their official purpose or some convenience, I have got no objection. I have no objection.
So in that case, we can dispose of 165. We'll pass the
Yes, Your
order.
Lordship.
And
May-
that
may I
part
please,
now
Lordship?
ordered, the other matters are in order from the election petition, which is the stage of the election petition at present
But
now?
there are positions like this. Earlier, your lordship has recently disposed of one IA,
Yes.
which was filed by us for the respondent, challenging the maintainability of the election petition. Lordship was pleased to reject our petition.
Yeah.
And there are two other IA. One is 65 of 2025, and the other is 115 of 214 of 2025.
65 or 21?
Madam, IA 65 we have filed.
Yes, IS 65.
Yes, well, this IA 65 we have filed again under section 86 of the Representation of People Act. Basically, a lot of contending that the signature of the petitioner appearing in the election petition are actually not his signatures. the petitioner did not put his signature in the election petition. And we have given reasons why we are saying so, my lord, in the body of the petition. And today, since the matter is fixed only for orders and for a different purpose, I only pray that a date may be fixed for hearing on this IA 65 of 2025.
Now in 65, IA 65,
Madam.
Gesto is here appearing. T Gesto is appearing here. Who is appearing?
Lordship, I am appearing. A Tatak, Lordship.
A Tatak is appearing.
Lordship.
Now this is the after rejection of the earlier IA, which raises the issue of maintainability. This has been filed again by the petitioner, I mean the return candidate or respondent.
In fact, Lordship, this particular IA was filed
prior to disposal of the earlier IA.
Prior to
IA 215 was taken up, and still IA 65 and IA 214 is pending, along with IA 190, Lordship. Now, this present interlocutory application, IA 165, Lordship.
No,
IA 165.
Only 65.
Yes, IA 165 is related to IA 190 that has been pending for a long time, Lordship. It is listed in the cause. IA 190, basically, Lordship, IA 190 is for preservation of the record. So I do not have any objection with regards to shifting of the EVMs, as long as that is kept in the safe custody of the district election officer. So may I pray that even IA 190 may be disposed of with the direction to the...
Now recently, recent IA is 165. That is the shifting of this EVM to strong room. That is okay. Mr. Mojumdar also don't have any objection. You also, I think you don't have any objection. Now, what about the 190 2024? What is this?
190, Lordship, it is for preservation of the records, including EVMs and then all the relevant records pertaining to the election, Lordship. So, in fact, IA 165 and IA 190, it's kind of similar. I do not have any issue as long as those EVMs and other records are kept in the safe custody of the
IA 190 2024 was filed by you only, I think.
Lordship.
Election petitioner file.
Yes, that is for keeping the...
Ms. Anju, you don't have any objection regarding the preservation of those?
Yes, no.
And Mojumdar, do you have any objection here? Okay.
So this can also be disposed of, 190, Lordship.
Yes, 190 can be disposed of. Similarly, 165 also can be disposed of. Now, coming to this petition, the issue raised by Mr. Mojumdar, this is 65.
Yes.
In regards to 65, there is an allegation that the signature was not the signature of the election petitioner. So in that case, have you filed any objection there?
Yes, Lordship.
But they have filed an objection.
Already
filed. Already there.
Objection is already there, I think.
Yeah.
Yes, Lordship. It was filed on, Lordship.
Yes. Yes.
March, Lordship.
March 30th March they have filed. Third of
yes.
Lordship may kindly fix a date for hearing on this.
Lordship, in fact, IA 65 and IA 21. Yes, IA 65 and IA 214 can be taken up together. Yes, it's 65 is has been filed under 86, and then 214 has been filed under Order 6, Rule 16, and Order 7, Rule 11 for rejection of plaint and striking out. So,
subject to what my learned friend said, these two applications cannot be taken up together. Because in IA 65, we have challenged maintainability on the ground that his signature is not there in the application, and that is filed under Section 86. Whereas IA 214 of 2024 is filed under Order 16 for striking out the paragraphs. That is different, my lord. If this application is taken up, and if we do not know, my lord, if it is allowed, then there will be no requirement of taking up this. But if it is only rejected, only there will be requirement of taking up the IA 214. So at this stage, my lord, IA 65 may be heard first.
अपना बेले IAS है first IA आता दियो and the election petition is in which stage? This election petition?
My
Election petition is in
Petition,
which stage?
petition, my lord, after your lordship.
Have you filed your this draft issues or documents?
No, my lord, we have filed our written statement.
Huh.
And issues have not been framed as yet.
Not yet. But draft
Madam-
issues are, I think draft issues are not also been
My humble submission before lordship will be, this IA may be taken up
yes,
first.
sure.
Thereafter, the
We'll pass
question
it
of
later.
framing of issues
Okay,
will come.
okay.
And one more thing I have to point out, my lord, in this IA 65, since we are saying that the signature of the petitioner contained in the election petition are not his signature, that is why, my lord, in order to prove our allegation, we have to see that the signature is compared with his admitted signature and the signature appearing in the petition. For that, my lord, we have filed a separate IA, there is IA 69 of 2024.
69.
My lord. That we have filed under order 16 rule 10A of the civil procedure code. I'm sorry, order 26 rule 10A with a prayer that the petition may be referred to the state forensic science laboratory at Bandedava along with a admitted or specimen signature of the election petitioner for comparing the same with the disputed signatures appearing in the body of the petition. So both these IS will have to be taken up together on the next day. IS
Let us,
65.
yes, let us hear the 65 first.
Yeah, no,
If there is a, we find that there is a requirement of sending this one for return, then definitely 69 and 65 both can be taken up together. Both 65 and 69.
yes, these two are actually it should be taken up simultaneously.
Sure. IA প্রথমতে আসো IA number 2 IA 165 2025 165 কি কই oh yeah মূল কথা আছে and so this is for by the election officer.
Yes, Your Lordship, District Election
So
Officer,
he
DEA.
is the respondent, otherwise he is respondent number.
Otherwise, returning officer is respondent number 2. He is, Your Lordship, District Election Officer is not a party in this
Not a
petition,
party.
but however, yes, Your Lordship.
Heard Mr. Sorry, heard MS A Anju.
Nanju.
Oh, sorry, N Anju. They done it. You at government advocate, no?
No, Your Lordship, Standing Council, election petition.
Election.
Of Election Commission.
Standing Council Election Commission. Also heard Mr. D. Mujumdar, they done it. Council appearing for the respondent of the return candidate. And Mr. E. Tata, the learned council appearing for the election petition of the respondent. It is this interlocutory application has been filed for shifting of all electronic voting machines, bracket of EVM, of entire 8 Bumming ST, bracket of ST Assembly constituency from Government Higher Secondary School, BEBO, BEBO, Colony, SEPA, which is being used as strong room for storing the election materials to strong room oblique warehouse of District Election Office, SEPA, East Camp. MS Anju submitted that is shifting of these EVM machines, etc., are required as these are being kept in Government Higher Secondary School till date. Mr. Mujumdar, the learned senior advocate, submitted that he has no objection in shifting his for shifting of the EVM machines from the Government Higher Secondary School to strong room of the warehouse of the District Election Office. Mr. Tata also raised no objection in that regard. In view of this, the present petition is disposed of and the prayer for shifting the EVM machines and the other electronic to strong room is hereby allowed.
Obliged.
The petitioner will take necessary steps in this. Now 60 come to 190, 2024. To dispose of 190, 2024. 190, 2024 was also filed by you.
It was filed by me, Lordship, election petitioner, for preservation of record, Lordship.
Or filed by you. Election
Yes, Lordship.
petitioner.
Election petitioner, Lordship.
Okay. Heart, Mr. T. Tata, the learned counsel for appearing for the election petitioner, and also heard. Here your name is also appearing, Miss Anju. You're not
Yes, Your
appearing
Lordship.
as a-
I'm for returning officer. I'm for returning officer.
You're for returning officer. That is the respondent number.
Two,
Respondent number 2.
Lordship.
Filed by Dissano, so and so, also heard. MSA and Anju, the council appearing for the standing council appearing for the returning officer. That is the respondent number 2. It is submitted by Ms. Anju that the present application has been filed for preservation of this the relevant records which are at disposal of the returning officer to the State Assembly for 8 Bumming st Assembly constituency in the election constituency system. It is submitted that by Mr. Tata that the preservation of this all the relevant records is necessary. Also, in this context, MS Anju, the learned standing council election commission, submitted that he has no objection in preserving all the electronic all the election all the relevant records pertaining to the said election. In view of this, the present I is also disposed of according with the direction to the returning officer to preserve the materials in connection with the election in connection with the 8 SC Assembly constituency. With the above observation, the present I is also stands disposed. I is stands disposed. Now come to 65. It Heard Mr. R. Mujumdar, the learned senior advocate, assisted by you, Mr. S. Bose. D. No, Mr. D. Mujumdar, assisted by S. Biswas, sorry. S. Biswas, the learned counsel for the petitioner of the return candidate, and also heard Mr. T. Tata, the learned counsel appearing for the election petition. It is submitted by Mr. Mujumdar that the present application has been filed. Will 65 be the one? 65. Challenging the signature signature of signature pertains to the election petition is not the signature of the, not the signature of the return, no, not the signature of the election petitioner and election petitioner, and which was, no, sorry. The present application has been filed under section 86 of the RP Act 1951 by the return candidate or the respondent, alleging that the signature which is available in the election petition is not the signature of the present election petition. In that regard, the respondent election petitioner has already filed a written objection. Accordingly, the present application may be heard along with present interlocutory application may be heard along with I 69 of 2025, 69 AP. Because when it can be listed, you want any fixed date here or after 3 weeks?
Let it be on 3rd of September. Let us make an attempt.
Mr. Tatak, 3rd of September is okay? 3rd of September, good debate. Are baki kina? All the election petitions of 3rd of September. 3rd of September. 65 and 69. 39. And along with this one remains 214 and I 19. These are also fixed on 19, 39. Along with the election petition 5 recruitment. Baki hin ekalage likh.
Okay, can it be taken up at 2 o'clock so that it,
Generally, your practices here that at 2 generally we actually record because we have to take it up through BC only.
Yes.
So generally 2. So even if it is not suppose mentioned, we ask the registry people to fix it.
Obliged.
That part he may clarify because after one of the applicant petitioner was given interim protection lordship by your lordship petitioner number 3. He went to the before the investigating officer. Even the order was thrown away by the investigating officer and his statement was not recorded. Accordingly, he filed an application before the superintendent of police. Thereafter, his statement was recorded. He was aware that one person is granted interim bail and today is fixed for case diary. 2 persons are behind custody, behind bars, lordship. In spite of that, he has not sent the case. Therefore, I'm placing the copy which was submitted before the investigating officer. This was duly received by the office. Even in fact, I have informed
This is in connection with that AB.
AB. Because he has the knowledge that cases is filed and interim order dated lordship
28/7.
Yes, 28/7.
So as per this received note, that was received on 1/8.
On that day, it was,
No,
yes,
the-
one
again,
SP receipt, 1/8 SP receipt. Because he was thrown away from the police station by the investigating officer. That copy I will not receive. He says like that. Therefore, he came back and informed me that what I will do. I have to inform him that you submit an application before the superintendent of police. That is the only report. And we have also tried to submit one application before the PP office. They said that we cannot do anything, so you just inform the court. So we could not file. So this is the conduct of the investigating officer. And the 2 persons, lordship, aged person, they are in custody for 68 days. This is clearly
Should not be. In fact, if it is there.
that is
Now, as per you, you have not received the case
yes,
there.
there.
What was the intimation from the IO then?
Not received any intimation, my lord.
He has not submitted any intimation also.
No, not.
Then. And as per your information, till date, your petitioners who was on interim, his
Subsequently, after receipt of, from
that has been
direction,
recorded.
probably from direction from the SP office, he received and accordingly, my statement was recorded. Applicant petitioner number 3. But because of that grudge, he may not have sent the case diary. That maybe.
That case managed where, perhaps.
Because he has the knowledge, he got the
If
interim
there
order.
be the contact of the police officer, that should not be.
Because
Order was there from the court, he is to oblige, he has to record.
That is their
That is
person,
not
but whether he is in that duty or not, that is different thing, that is not ever matter.
See, that is not before us, but the question is that if he could not send the case diary, suppose, then its duty is to inform the court.
He has to
It was
intimate the
called for
court.
only, requisition was also given in Bunda cases,
Yes.
So that may be given,
Where you have sent your requisition?
in AB, BA, 25/7.
BA.
BA.
It's quite long, I mean.
25/7,
yes.
Even after that, his
AB,
statement was recorded.
20, no, on the same day, on the, no, 28/7 in the B,
And in fact, his statement was subsequently recorded and the investigative officer also received the interim copy of the interim order. Wherein, Lordship, the date is fixed today, Lordship. It is specifically mentioned in the said order also. And 2 persons is custody also 68 days.
Quite a long, I mean, reasonable period they are in custody.
That is also 103.
Obviously, 103, that was there.
Oh, if
But the
material
question
is there, my bail will be rejected. I have nothing to say. But at least he cannot interfere in the judicial process, Lordship. That is my whole submission.
It has to come from which?
South Salman.
Mankasar.
Mankasar.
Lordship, we are fixing on Monday, Lordship.
Monday?
Because it is their fault. It is not my fault. I am behind the bar, Lordship. Because of their fault, I am behind bar. If my application is rejected, then I have nothing to say.
Not for that one, so Monday may not be possible. It may not reach also. There are 2-3 long hearing matters have been fixed. 19 can it be fixed? Or 19 is 30 matters.
Considering the present case, Lordship, that is there. Because of that reason, I am paying.
That I am not denying, but
No.
even at 19, no,
On 19, Lordship, we will try our luck, Lordship.
well, it's from Bunwar. Yeah, Purvatas. But as most probably he informed, many matters that he fixed. I don't know. এইটো মই কৈ আছো এইটো নহয় মই জানো এইটো নাই তেখেতক দি দিম জিতা be able to take up heard Mr. A. Ahmed, the learned counsel for the petition. So heard Mr. B. Sharma, the learned division VP, appearing on behalf of citizens. Next, it is submitted by Mr. Sharma that CD not received. In that conflict, Mr. Ahmed, the learned counsel for the petition, submitted that the case diary was intentionally not sent by the IO. As from his conduct, it reveals that none by the IO was to be further submitted, and after getting the order of interim period failed, the petitioner appeared before the IO for his cooperation and to record his statement, wherein the IO did not respond to his submission and the order of the court, and for which he had to file an application before the concerned police station, which was also received with seal and signature on 1/8/2025. Thereafter, the petitioner also moved an application before the SP of the concerned district, and only on the direction of the SP, his statement was recorded by the IO. Accordingly, it is submitted that the conduct of the investigating officer is not cooperating, and that may be the reason the CD was not sent by the I. However, Mr. Sharma submitted that the requisition was sent to for sending the CD on 25/7/2025 in both the matter, but it has not been, it is not received till date. Considering the submission made by Learned Counsel for the petitioner, the IO is hereby directed to furnish the case diary on or before the next date of listing without any default, positively without any fault, positively on or before the next date of listing. In default, you will be served with a personal show cause notice. Personal show cause notice. Next, list the matter accordingly. When you are claiming full to date of the 19, 19, 20, 20 of the H A to the ABPA to the
Copy of the order.
sorry, interim. That interim was granted to only one
Only,
petition. I think.
yes, petitioner number 3.
3. The interim granted to the petition number 3 be extended till next year. BA to pick up BA.
A copy of the order may be given to me.
Copy of the order may be furnished to the Learned additional PP for necessary for necessary compliance. BA to pick up heard Mr. A. Ahmed, the Learned Counsel for the petition. So heard Mr. B. Sharma, she did not receive. It is submitted by Mr. that both the petitioners are in custody since the 68 days, and hence considering their length of detention, they may be released on bail. However, it is however, it is submitted by Mr. Sharma. The perusal of the case diary is required, as it is the case of case and as it is a case registered under section 103 BNS. Issue reminder, list the matter accordingly on this 20/08/2025 along with AB number 1740.
Interim order that regarding petitioner number 3 may be
continued.
Problem.
At the motion. One of these petitioners are father, mother, and brother.
Yes,
The main accused.
My lord, CD not received, my lord. It's not.
You'll also kindly see my lord.
PM report was called for, my lord. Hazu, my lord.
Hazu, your lordship, last time it was called for one. And only intention was that the father, mother, and my husband already arrested, my lord. Already arrested. So I have come for these persons, my lord, your lordship will find they are also aged persons. 64 years, my lord, 50 years, father, mother, and can is the FIR, my lord. The allegation basically, my lord, just one line is there, they together, all of them together, they have that. But in fact, my lord, your lordship knows in this type.
Okay, I can understand, but the question is that it's a case of murder.
That's
Minimum petition is required. That is
there, my lord. But
they may not play this such then.
That is what I'm saying.
Can understand there may be.
That's why the CD was called for, my just to see. One
So
that
why CD is not received?
Hazu, my lord, here.
My lord, no any intimation, my lord, but not received CD, my lord.
This, you know.
But very sorry to say, so we don't have any. Somehow, one date was somehow Mr. Burwa managed. Now, so next week, yes, Burwa, what to do? We don't. Yeah, I think it's a very.
We understand also problem your lordship face. We understand, my lord. What is to be done, my lord? Phone could be done. Huh? Personal, no personal.
Number say five.
Small stuff like. আমাকে কাকে দিবা? Parents, the bed to the parents. No, it was all.
Maybe. Somehow managed to stay somewhere here and there.
Oh, we understand, madam. That is there, your lordship. That's
Well,
it.
still
All I-
21. Somehow he gave me 21. Or you
21.
only 21. Rest of we could have in the month of September.
Father, mother, only that's anyway, madam. That's
Father, yes, father, mother, but
normally this type of all are entangled, madam. This is the problem, madam. Already, husband already.
I just came across a case while I was in family court. That the allegation brought by the daughter-in-law that she was subjected to mental and physical both cruelty. Especially she brought the allegation against the mother-in-law. And now mother-in-law, as per them, the mother-in-law is in bedridden condition. Then I asked her that how you brought the allegation against your mother-in-law, she remains in bedridden condition. Then she explained how the mother-in-law was torturing her mentally, not mentally, even physically. She was asked to put oil and all in for message and all for his
It happens, madam.
and then she used to kick her. So in fact, if you go by the scenario, then the lady of aged lady, she is in the bedridden condition most of the time. So how can she? But these are the questions. So
In some of the cases, it happens. I also know.
there
Just
are
fine,
some.
but yes, but there are cases.
Here may not be. The fact
May not be, maybe, might have. 60.
Your petitioners may be innocent. Also, that I'm not.
5 years, madam. Yeah. Anyway, madam,
5 is you are don't mind. I'm just asking you are.
more than 75.
Then what to say? Then what to say?
No, I'm not. As I look, madam, I don't say.
Huh? Oh.
I am not the way how I am looking, madam.
Ah. No, you are 75 plus, suppose 75. Now he is only 55. See. Now 60, 65 is, I don't think is, I mean, what to say.
Well, there are people who 40 years also they are sometimes inactive, my lord.
Oh, yes, there are.
Sorry.
Anyway, somehow we're fixing it on
21.
21.
That is Wednesday.
No, I don't know. 21st is, I don't know. Do you have anything?
Not a problem.
21st of this August only.
Thursday, man.
This is Thursday.
Okay.
May I please your lordship?
Yes, what is 35? Yes.
Yes, my lords. This is the criminal revision petition filed on 6th of this August, my lords. Actually, we had to take steps with regards to service of notice. But however, there is slight difficulty here. In the our revision petition, the private party who is the complainant is a respondent number 1. And in the order, my lords, to take registered post, it was written as respondent number 2.
Oh, achha. He is just for number 1 in.
Yes, the
State is just for number 2.
Yes, my lords. 138 NI Act, my lords.
Oh, achha, it's NI Act.
NI Act, my lords.
Somehow it did mistake. Oh, we'll make a correction.
Yes, my lords. And secondly, my lords, actually notice was issued, but the suspension of sentence was actually not provided. There are 2 things, my lords, here, if I may fairly submit. Actually, an NBW was issued. NBW was issued pursuant. This is a revision against the appellate order. I am the accused in the case.
Yes.
My lords, personally, NBW was issued. The reason my lords did not consider the prayer for recall of NBW because that order was not there. In the IA, we had to file an additional affidavit, my lords. We could not because it has to come from Shirang. We only got it today, my lords. That is the only issue. So, my lords, I just pray because the judgment is of 14 July and the statutory period for appeal will be, as I can see, the court is quite crowded, my lords. Therefore, if the time it comes on Monday or Tuesday, whatever, whatever my lord allows, the statutory may get over. So till that time, the suspension of sentence with regards to the criminal.
Now statutory, that way it won't count now. Your this I is for what?
Recalling of the NBW.
Recalling of the NBW.
NBW.
So you have already filed your criminal revision petition.
Yes, my lord.
So that limitation will be covered. There's no issue on
Yes,
limitation.
my lord. So in the
Because
order-
even if suppose it is the limitation period expires or someone, but you have already filed your criminal
yes,
petition
yes.
within the limitation.
Yes, my lord.
Okay.
Yes, my lord. I'm so
Issue
obliged.
will be-
I'm so obliged for that, my lord. Only in the order, my lord, that correction, whatever my lord has
Yes, we'll
filed,
make
whatever
the
following,
correction
my lord.
here today,
Yes, my lord.
today only.
And if
And
the
but you have not taken steps
steps because of that
because of numbering.
numbering, my lord.
Okay.
And the only thing, if the suspension of sentence can be mentioned in the order, my lords, I'm suspension of the sentence as per the criminal appeal. Yes, my lord. Suspension of sentence because the accused in this case in the appeal was actually convicted.
Yes, yes, I know.
Yes, my lord. Yes, my lord.
Suspension of sentence, let
But
me
for
heard.
that,
Really
notice
matter.
will
How
have
can
to
we
go,
pass
madam.
now? Huh?
For that notice, you will have to go.
That for that only.
After hearing the
we
parties,
know.
then
Ah.
there is a condition, madam. If the
Notice
second month,
is
they have
required,
to
that
pay
is not.
20% for admission, madam. That is also there, madam.
No, in the
They'll
in a
have to
case,
pay
my lords,
amount.
my case, yes, I'm so grateful for my learned
Ah.
colleague. In this case, actually, what has happened, my lords, my case was that during the pendency of the appeal, my lords, there was a money receipt where the complainant actually, so the accused actually gave a cash of 3 lakhs out of 8 lakhs, which almost covered 30 to 40% of the accused debt. However, despite that, in the money receipt, the witnesses were the 2 advocates from both the sides. I have mentioned it in the petition in the
No,
last.
these are things which come
Yes,
later.
but
We'll
that
see.
was not even mentioned in the appeal, my lords. During the appeal, we gave that. So with regards to the statutory money, as per
Now,
140
as you have already submitted that out of 11 lakhs or out of 8 lakhs, you have already paid 3 lakhs.
3 lakhs, yes, my lords.
So if that be the position, suppose if this comes, then otherwise it will be a case that you have admitted of one party. Suppose. No, that's why I'm asking, is there any probability of any settlement? If it is there, then definitely we are taking a step for sending all these kind of matters to before the mediation for settlement.
Yes, ma'am.
Because you have submitted that after 8 lakhs, you have already filed
Paid 3 lakhs.
3 lakhs.
Yes, ma'am.
So if there is any negotiation, any
ma'am.
suppose the interest parties waive or is there any
Yes,
kind
yes,
of
ma'am.
thing, settlement, then
Yes, ma'am.
we can send it. But that in that case also this presence of the respondent number 1
Yes,
is
ma'am.
required.
In-
So
ma'am,
I now just will correct the name.
Yes,
I mean numbering of this
ma'am.
respondent and we'll see to it afterwards.
Yes, ma'am.
You take steps immediately.
Immediately, my lords, I'll
Immediately.
take the steps. Ma'am, and secondly, ma'am, with regards to listing of the IA for recalling of the NBW, which has been issued, that may be a short date may be given, my lords.
No, we don't have any short.
A short date means, my lord, in the next week.
No short date at
No,
all.
because he's apprehending arrest because of the NBW, my lords.
But
It will
in
be
that
one
case
short
also
commission.
it won't help you because if the other party is not there, it has to be heard. Nah, that's why.
I believe, my lords, for the recalling of the NBW.
Recalling is which is the IA, recalling for recalling.
IA is, my lords, 845. 845 of 2025.
We'll see to it.
Yes, my lords. Recalling of the NBW.
You are Mr.
M. Burman,
M.
my lords.
Burman. Heard Mr. M. Burman, the learned counsel for the petition. I also heard Mr. P. Sharma, the learned additional PP, appearing on behalf of state respondent. It is submitted by Mr. Burman that inadvertently the steps could not be taken to the respondent number 1, which is no. The steps could not be taken to the respondent, but inadvertently not like a respondent, as in the order dated 6/8/2025. The respondent number 1 is mentioned as respondent number 2, to whom the steps is to be taken to register it. From on perusal of the record, it's seen that the state is a formal party and it is stated it is mentioned as the numbered as the respondent number 2, state respondent number 2, and the respondent number 1 is the private respondent. In view of this, let the petitioner is directed to take immediate steps on the respondent number 1 to register AD and as usual process. Let the matter be listed along with IA criminal 845/2025. Order to Nayata Devi. 28/8.
No, I'm so sorry. 20 or 21, my lords. It will be very short because it will be hearing only on the IA. Nothing more than that, my lords. Only the order I have to submit, my lords.
and whatever my lords will following from my lord, it will be very short IA. It will not take more than 5 minutes plus.
No, you may not talk more than 5 minutes. I
For-
have
for
the
my
lot of
submission,
work
well,
in the chamber.
Well, I'm so sorry. I understand. my lord.
For you, for 5 minutes,
Yes, my
for
lord.
me, it is.
My
1
submission
hour.
is not more than 5 minutes. I'm saying from my submission, my lords.
21.
Yes.
21 inch.
Yes, I'm so obliged, my lords. I'm grateful.
Maybe 1, 2, 3.